Then I have to prepare the charge.
Possible.
My lord,
Very difficult to.
no, your lordship will allow, my lord. There is no difficulty.
No, it will be listed, but taking up is difficult.
That's a different aspect. I can show to the court that it will be.
Huh? 200, cross 200.
Might be. Which also, I will mention.
24th. Then at least he can get it.
23rd, your lordship.
23rd is crossing 200.
Your lordship.
Not even to touch the files.
If I will mention, I will make a mention on that day before.
That's right, but all the matters are like that.
You lordship may say that 23rd, then
23rd log
I can show to the court concerned this is listed. This.
And you seek urgent.
Pardon to mention, my lord. No, earlier this matter is listed, but could not reach, my lord.
Give the memo, we'll see. This after vacation only, I can't help it.
I will be pardon, your lordship, and phrase CRLMC, your lordship.
You give the memo, we'll see. Nothing happens this side of the vacation. Yes.
Can I play item 7?
Yes.
We call it after vacation. I am told that the decision was time, but I am not sure.
Okay. On request, adjourn. Okay. Any adjourn? 6. Can I call from page wise so that it will be easier? Page wise. Okay.
Item 1 to 6. Item 1 to 6. Today I saw the copy of the.
Which one?
Item 1.
You are the
for adjournment.
You are respondent.
Petitioner lords.
Petitioner. Okay. Adjourn.
What the purpose of?
On request. On request. Take. On
After
request.
vacation.
Petitioner.
Your lordship, I wanted to mention a matter, your lordships.
1 minute. I'll just complete the pages. I'll just 1 minute.
One is also CBI. Item 1 is also CBI matter, your lordships.
Item 1, he's asking for adjournment.
After 10th January, it may be listed, your lordships.
After January. Okay.
Item 7 to 20.
Seven.
7. And let this vigilance also take.
After that. Okay.
21 to 31.
Lordship, I am appealing from item number 6.
Item number 6. Yes.
I'm seeking a short passover.
Yes, sir. Item number 6. What do you want?
I am seeking a short passover.
What is he asking? We'll see. Let it come. Next.
May I please, Lordship? Seeking a passover, short passover. Lordship.
Yes, it is Passover. No problem. Yes.
May I please, Lordship?
30.
32 to 44.
Yes.
45 to 48. 49 to 57. 58 to 64. 65 to 72.
So 72 may be taken up today, my lord, because your lordship yesterday seen that judgment, your lordship.
I'll take it up. Yes.
Item 68, notice has been issued. My client has received the notice, but he could not give the wakalat now because his father is ailing.
What do you want? I'll put it after vacation. After vacation. 68. Yes.
May I please?
Yes. Any mentioning? No.
Lordship, day before yesterday, in item number 24 was listed, Lordship. Day before yesterday, Lordship.
What do you want?
Lordship, actually, what happened on the relevant day at the time of the hearing of the application, Honorable Court directed to be listed that case on 24th. 24th of this month, Lordship.
Then
But
what?
but the order which is uploaded in the internet, it shows that the case is posted on 10/1/2024, Lordship. The 25th.
See, this side is not possible because the board is completely, full. There is no chance. So that's the reason.
Lordship,
You move application, I'll prepone it. You move application, I'll prepone it. Okay.
Mentioning was there.
Yes, Mr. Naik.
Your lordships had given a memo CRLMC number 2909 of 2022. Your lordships had specifically listed that matter after allowing the mentioning, your lordships. But on that day, your lordship, there was some program in Puri, your lordships. Then the matter was again, I asked the court master, it was listed on 16th. This is that, your lordships, Paradip Port matter, your lordships.
What is the urgency? It can be taken up immediately after vacation.
Your lordships may fix a date after 10th January, any date.
After 10th January, fix it.
Lordship may indicate.
Give the number. You can. His memo is there. I'll fix the date after 10th January.
Yes, Your
Fixed
Lordship.
date.
Your Lordship, the urgency is that the investigation is pending, Your Lordships. We have to collect the voice sample of the accused.
It's all right, 10, after 10.
I beg your pardon to mention, my lord. Yesterday, my lord, one item was listed, item number 84, my lord. My lord has directed this matter to be listed on 24th of December, my lord. But somehow, my lord, in the order sheet is reflecting the matter has been postponed to 13th of January, my lord.
I don't know what happened. I'll have to see.
So
Just
24.
give the number, we'll see. If it is already uploaded, then you have to move application.
Yes,
I
have
can't see.
applied an IA also, my lord.
All right, let's close.
Pardon the mention, Your Lordship. Yesterday in the list item number 37, Lordship, inadvertently that has been mentioned the state of Orissa, that is CBI instead of the opposite party CBI. Lordship has directed to list today, Your Lordship. But matter has not come today, Your Lordship may take it up on Monday, Your Lordship.
Which item?
Monday, 200 matters, I am already completely,
Which item, Your Lordship?
Consolidated cost items.
But you see, there are documents also you have not filed. Couple of documents, I remember. You have to change the cost title as well as some document is required to file. That's the reason it is a
Conviction matter, 3 years, Your Lordship, yesterday.
Yes.
Yes, his bad state as a party. Lordship has detected the state of Odisha and the CBI is the party.
Which item, Your Lordships?
No. Have we changed this?
Yes, Your Lordship.
Which item?
24. Yes.
Copy to the
You give a copy to BCBA.
Yes, sir.
Mr. Naik's associate must be.
Item?
No, it's a fresh appeal, 3 years conviction and for admission. So he'll give a copy. Give a copy. Okay. Give a copy to Mr. Naik's office and let it be on 24th. No problem. It's simple. Yes. Can it be taken up today? Bring it.
Not possible.
Not possible. Okay. Yes.
Item 2.
Yes, sir.
May I please, Your Lordship?
Yes.
The petitioner is a physically handicapped person, my lord. He was appointed as a Gram Rozgar Sevak Yojana. And my lord, as per the systems of the block of his, as per the system of the government, Pradhan Mantri Awas Yojana, my lord, a house was granted in favor of CORAM Sahu. Here, my lord, subsequently has paid the amount to the persons, to the beneficiary, and is a physically handicapped person. If Your Lordships last time, if it is a question of negligence and if he has actually paid, then why he should face a trial? But that aspect, the Lordship wanted my friend to examine.
Yes.
He has paid. my lord. He has paid.
Yes, my lord. This petitioner was the grammar Rozgar Sevak, and he has there is a master rule who is work for that construction of that draft. This petitioner that record was maintained by this petitioner, and one Bora Shaw is the complainant matter.
Yes.
He has given 4 names, I think, 4
Yes.
5 names, I think. And he has completed the work. Thereafter, my lord, inadvertently this petitioner has, without giving the money to that Bora Shaw, has given that person who was working that person's, my lord, as per his version.
Yes.
The Bora Shaw koitla he man lukone kam kare. Seman ka account pade. Then Goram Shaw he has not got the money. He has complained before the collector. Then collector made an inquiry. In the inquiry, it is found that without giving the money to that Goram Shaw, the money has been transacted to that 2-3 persons. Then FIR was lost as per the PDDRPM. That FIR indicates, my lord, there is also the story of the FIR.
Yes.
That FIR. Yeah, next in the
What is the name? Rasmi Ranjan. Let us come to the charge sheet.
charge sheet.
My Lordship wanted to know whether he has paid or he has misappropriated. That is-
Let us see.
Charge sheet that is, yes, my lord, in the brief, my lord, 26 euros.
Yes. I'm there.
May I place? May I place?
Yes, yes.
Second paragraph.
Okay.
As per order of SP Kendrapada, Srimati Pandharani Beurya OPS Patamde, please to first paragraph.
Patamundai, please to
First
supervise.
paragraph, the prosecution case. Kendrapada district case, during course of investigation, then I was so and so visited the spot, examined the complainant as well as witnesses, and recorded their statement under section 161 CRPC. He has received message from DPO Kendrapada had memo number so and so, that this case will be supervised so and so. All that the Rosmiranjan Korida, Babaji Parada so and so, Kendrapada has surrendered in the court so and so. Subsequently, received the charge of investigation so and so, requesting him to provide the most of our Panchayat Samiti for seizure regarding the misappropriation of money.
Now, what are the material which is came?
Material. Your Lordship, I may permit it to show my friend, my lord, that Balaram Sahu, the same Balaram Sahu, has received and he has also.
Have you checked it? Check it.
Balaram Sahu has received.
Last week I am keeping it. Check it. Please give it so that
Yes, yes.
you can check it. See, with the money, it's a matter of money transaction. He has paid it.
And I
Unnecessary, why to trouble this?
The persons who has smelled, they also stated wrongly on my account of pressure.
They shall know.
Then what else? You just check it up. I'll put it in first week and finish it up.
Fine.
Lordship.
Right on. Council for the state.
Lordship, dispose of.
Seeks an adjournment. No, he will verify the money part and through IO get it verified.
I have shown him, my lord. I have already shown.
He has to verify that Council for the state.
And your Lordship is also sympathetic because he's a physically handicapped person.
See, ultimately these cases will be end up in a. It is a burden on the court, basically.
Because DR para.
So therefore, get in the proper, from IO get in instruction. FIR, the law doesn't mean that every case you will file charging. These are the cases closure report should have been filed. Where closure sheet reports is not to be filed, you will file.
Because the record shows, my lord, the 7 toka nahi because whole toka transaction.
Full rate transaction is the day the sarla kaam khatam.
They.
छोटे matter instruction niyantu. I'll keep it on 6th. I'll keep it definite instruction. Monday 200 matters, sir. It's not possible.
It's a small matter, my lord.
Monday may not be possible.
Small matter.
Let it be the reopening day right now. I'll record that. Mr. Naik Council submits that the LS money which was wrongly not paid to the victim, has already been paid back to them, and all the so-called victims have.
Without giving the beneficiary manner, he has given the workers who was engaged by the
Mr. General Council for the state submits that instead of making good the payment to the beneficiary, the present accused has paid the money to the worker who has been engaged by the beneficiary. Engaged by the beneficiary. Engaged by the beneficiary. And be that as it may, the transacted money has already been paid by the petitioner. Petitioner. Mr. Jana submits that he would seek a definite instruction regarding this aspect. Please the matter of 6th. Get it? Yeah, so that I'll close it. Okay. I record it.
And for the petitioner, your lordship.
And allegation petition.
mediation report.
Successful.
No, your lordship, actually opposite party too did not appear on the last occasion. Only one sitting has happened. And the matter has been posted to 7th of January.
7th, after 7th.
Great.
Awaiting mediation.
Item 4, my lord. I'm challenging the annex of 5, my lord, which was my discharge petition was rejected by the trial court matter.
Yes.
The charge sheeted against the present petitioner under section 294, 506, 34, 507 of IPC matter. Charge sheeted as shows as absconder of the present petitioner matter, and I am released on bail, pre-arrest bail before this honorable court, that is annexed 2 matter. Here the case is that there's a 2 number of accused matter, father and son.
What are you challenging?
Challenging the discharge petition.
Yes.
Annex of 5.
You filed a discharge petition which has been
Rejected
rejected.
by the trial court.
Yes.
That is annex of 5.
Yes.
Here the proper the case is that here the 2 number of accused are there, father and son. Present petitioner is the father. accused against the son is that he having some relationship with the informant daughter minor, and they forced her to keep physical relationship. When the father of the accused known about the particular fact minor, he give a proposal to marriage between both of them minor. The parents of the girl denied that. That's why the present petitioner called telephone call to the victim's father, and all the accused, all the allegations against that particular person. In the lordship, in the victim 164 statement,
Show me.
which is Annex 4,
Answer 4, yes, read it.
not a single word uttering against the present petitioner. Page 30, page.
Yes. What in the charge sheet? What are they? Yes, yes, I read it. Charge sheet. What are they?
Charge sheet is minor.
Yes, Mr. Janna.
My lord.
It is between the his son and the that lady. What the father will do?
Father is, my lord, that is page 2 of the
What
order.
is his role? Yes.
That order of the Lord, and so because this is a first time, my lord, according not to be.
Just see. Oh.
Having heard the Lord and counsel for the respective parties and on perusal of the materials on record, it is found that charge sheet has been submitted against the present accused so and so. One Guru Charan, father of the victim girl, is the informant of this case who elaborately narrated the facts of this case in FIR. It is categorically alleged in the FIR that when the informant approached the present accused, who is the father of accused Sapan Kumar Naik, to prevent his accused son for commission of the offence as alleged technically, but the present accused, instead of preventing, accused son on giving threatening to the informant to give his daughter in marriage with the accused. And there are allegations, my lord, that the record is not with me, my lord. So what are the allegations?
Father, what to do? Son was in relationship with that girl, and the father supported the son.
Foxo is there, my
Lordship, daughter
record may be called.
I just issue notice. Let us see. Yes.
Don't stay.
State, I Foxo type stay.
Stay. No stay. Foxo is there. See, Foxo is there. Allegations are there. Not that allegations are not there. It's not a case of discharge at all. Because you have threatened. You say that I will kidnap your daughter. I'll see how you will not get your daughter married to my son. And she is a minor child.
Foxo is the son minor. Allegation of
No. You have awaited. You have awaited. That is the allegations, and the statements are very clear. You have said that if you will not get your daughter married with my son, I'll kidnap and take your daughter and all these things.
That's a 160.
Okay, I'll issue notice. If you then merit, if you want, I can pass an order.
No, ma'am.
It is a case. It's not a case of discharge. But the only thing is, they may consider father-son some emotional relationship. That's the reason I'm just exploring the possibility. That's all. Yes. 5.
Item 5.
Right, please, my lord. So the chutti for it.
You have declared holidays from today itself.
Actually, technically the blank check open, but we have to argue on that blank check.
Okay.
Item 6.
Yes.
I'm to Milord. If someone has appeared on my behalf and have taken password, since I had a matter, item number 3 in the court number 11.
No, it's voice is shaking.
Just yes, Milordship.
Yeah,
I'm through with
now
Milordship. Milordship, my associate has just taken the passover as I had a matter in the court number 11. But now
Yes,
it's over,
yes.
Lordship. I am.
It's all right. You
hearing.
carry on. Yes.
Milordship, the sound is not. Hello. Yes, Milordship. Yes, Milordship. We have filed this 482 petition. Actually,
You are supposed to file some reply.
from last 5 days, Lordship, they have not filed.
Yes. Yes.
IO has not come, my lord. For that reason, we are not able to file, my lord.
He is supposed to file the affidavit, but he could not.
But what your lordship said, let senior argue.
Lordship can see the last order. Last order passed by my lord. They had sought only 1 week time, and Lordship had given them 45 days time. But even after that, they have not filed
That is ready,
the Lordship, if the certified copy of the order sheet is already on the judicial file, I don't think there is need to file any affidavit. Actually,
Okay.
the order passed was against the settled proposition of the Honorable Supreme Court in series of matter, whether the Sanjay Dutt matter or the
What are you seeking in this petition?
Lordship, I am praying to quash that order of remand. The charge sheet, the application was filed by the learned IO to extend the date. Lordship, the law says that the notice has to be served on the accused or to his lawyer. My lord can see the page number 34 of my bail application. I have annexed those orders, Lordship. It is evident that neither the notice was served to the party or to his lawyer, neither the party or his lawyer was present at the time of the extension of application. So the order suffers from the violation of rule of natural justice. And there is a strict guidelines of the Honorable Supreme Court in Sanjay Dutt case or Ravindaran case and series of orders that the presence or the notice either to the party or to the lawyer is must. So that the order of sending me to judicial remand by that order is nonest, and that order needs to be quashed. So I should have been jailed for maximum of 6 months, but from last 4 years, Lordship, I am in jail. And just a week ago, this Honorable Court, the Honorable Supreme Court has reiterated that in case of personal liberty, each and every day counts. Each and every day matters. And from last 3 to 4 months, the matter is just fixed to file the affidavit, and they have not. I don't think there is need of any affidavit. If all the materials,
Show me the judgment of Supreme Court.
Yes, Lordship. Yes,
Where
Lordship.
for extension of time for
Yes, Lordship. It's on the
filing
page
charge
number 8.
sheet, notice is mandatory.
Yes, Lordship. It's on the page number 48. Ishwar Tiwari of this Honorable High Court only.
48, huh?
Lordship, page number 48 of my bail application. First point, may I read, Lordship? Report of the public prosecutor indicating the progress of investigation must accompany the application for extension. Lordship, here there was no extension application filed by the...
No, it says that there is an application.
Lordship, the extension application has to be filed by the Learned Estate Council, not by the IO. This is the law. Second point, a specific and compelling reason. Okay, it's okay. Third, a notice must mandatorily be issued to the accused and he must be produced in the court whenever such an application is taken up. Fourth, an application seeking extension of time in filing of charge sheet by the prosecution ought not to be kept pending and must be decided. Okay. In case where any such default occurs, the question of his being contested does not arise and a right accrued
How
in the
many
favor of
questions are there here?
My lord, as per charge sheet, my lord, there are 9 accused persons are there.
Yes.
And my lord senior is arguing that since mandatory provision, the notice should be issued, he has not given any notice. And for that reason, in the judgment which my lord and senior is relying, that your lordship may kindly have a glance. That is in relating to 167(2) of the Shapish, my lord. There he is claiming default bail. But here is case, he is saying that since that order has been complied with, that after that investigation closed, cognizance has been taken, he has not prejudiced, charge has been framed, he has not prejudiced and not taken any steps for that. But on the contrary, my lord, he has filed a bail application. This honorable court has granted bail, interim bail. Then he was fled away from the justice. Ultimately, this court has a monitor where he is. Then imbue was issued. Subsequently, he is apprehended and he was taken to custody. And this honorable court has...
A charge has been framed now.
Charge of 3 witnesses have been examined, my
At this stage, yes, at this stage, you should have come on this stage. When have you filed this petition?
This petition was filed, my
May I submit something?
On 24/8/2024, my lord. And his...
Yes, Mr. Monor.
Just as my senior argued in this matter, that if there is a delay in filing the charge sheet, then we can file an application. That is very separate thing. But if the prosecution makes any application to extend the timing of the filing of the charge sheet, then section 36A4 must be complied. It is the mandate of the law, not a judgment. I have annexed on the page number, Lordship, page number 8 and 9, 8 of my bail application. Hitendra Vishnu, judgment.
Yes.
I have quoted in Hitendra Vishnu's, when a petition is filed by the public prosecutor seeking extension of time to submit the charge sheet, it notice should be issued to the accused before granting such extension, so that he may be have an opportunity to oppose it on the legitimate and legal grounds available to him. Be it noted here that the said decision pertains to section 24A of the Tata Act.
So that is
which
the reason I wanted to know whether notice was issued or not.
No, Lordship,
And
no, Lordship.
from
Lordship.
from the impugn order, it is not reflecting anything. So
Yes,
they have to,
Lordship.
you file counter is necessary in this case. Counter is necessary. Yes. File the
Lordship,
counter.
then it be taken on a Monday or Tuesday.
Not
Lordship.
Monday. Absolutely. Yes. Next.
Lordship,
Charge
any
has been
date?
framed. You came 2018 order. You came in 2024. What is the pressing urgency now? You allowed the court to proceed. Cognizance is taken. Charge is framed. Evidence is recorded. Thereafter, you are questioning the extension of time file.
After that 17
And what is the urgency? Great
One last
urgency.
humble submission.
Put it in.
Lordship, one
Yes,
last
next.
humble submission. If the custody is not in accordance with the law, delay will not validate it.
But 160.
I am not saying that. What is the pressing urgency that in the overnight it has to be heard? That's what I am asking. Without counter. Counter. Let the counter come. Let the counter come. Yes. Next.
My lord. Any date may be specified, Lordship.
Yes. Yes. Date he will indicate it. Yes.
My lord,
Page 98. And it's to 7.
same charge sheet, same FIR. I am one of the accused.
98.
Again. I'm one of the directors.
Page 80 or not? Just assist.
Page 80.
Page 80.
ସେ କହୁଛି ତ ଆମେ କାହିଁକି
80. Okay. 1 minute. 80.
ସିଏ ପୋଲିସ କରୁଛି ପରା ନାଇଁ କର
80.
Second para. That is attributed to the judge.
Yes. Investigation
It
reveals.
is to be interpreted.
The investigation reveals that Hind metals.
Yes. That para will be incorporated in your judgment.
Page 8. Page 8. 80 para 2. Para 2.
ସବୁବେଳେ ଇଣ୍ଡିଆ ଷ୍ଟେଟ କାଉନସିଲ ହେଲେ ଆମକୁ କେତେ ସୁବିଧା ହଉଛି
No, sir, this is the real job of a state council.
that I know.
State council doesn't mean that for everything you stand up and.
When I was Advocate General, I
You
was
are assisting the court. You are not.
Justice Gowda was the Chief Justice. I was the Advocate General. So in one case, my AGA was vehemently arguing. I was hearing that case. Then I stood up and told, well, Lord, dear mercy on my concession, my quasi,
That's
the order.
That
Then-
should be the.
Then Mr. Gowda, Justice Gowda laughed and said, "Now why will record your concession?" Mugati, my lord, being an Advocate General, if I cannot concede, I am the Advocate General for state, not for the government.
Right.
I cannot concede your lordship, my right, nothing will happen to me.
That should be the spirit. Otherwise, it is.
And your lordship's order is page 98.
Judgment tagi ଅଛି.
Judgment page 98.
Next that judgment, my lord, your lordship.
Judgment ତ ଲଗେଇଛନ୍ତି ନା ଆପଣ?
ଆଜ୍ଞା।
98 ରେ ଅଛି।
ଆଜ୍ଞା।
Page 98 will be there.
ସେଟା ହେଲେ କଣ କି ସବୁବେଳେ ହେଲେ we also carry an impression of the unlimited that.
No, that is very important. Towards this, huh? ठीक है।
In pursuance to lawsuit that I have mentioned earlier, in that case, he has appeared and taken back all his attributes.
Which one you are talking?
Nine.
My lord.
Yes.
Item 9.
Huh? Infectious? Much. Infectious. Yes.
10.
My lord, kindly pass over.
Yes.
11.
My lord, item 11.
Yes, 16. Without DA case, without sanction.
No, not only sanction, my lord, let me place my lord. The petitioner is an advocate. He enrolled in the year 1984
By now, he has put in 40 years of practice. For a small period, he was appointed as the chairman of the Orissa Cooperative Housing Corporation. During that period, a DA case was instituted. During course of investigation, I was called upon to explain what are the source of income or how. I placed all the documents before the investigating officer. That has been mentioned in paragraph page number 4. That myself and my wife were filing the income tax returns, and those matters were inquired into. The IO has collected all the income tax documents during the course of investigation, and it formed part of the charge sheet. On the basis of that, I filed an application for discharge, my lord, because no case is made out, my lord. In reply, your lordship may kindly come to page 16.
Yes.
Page 16. That is the reply of the vigilance. Paragraph 2. May I place, my lord?
Yes.
That it is a fact that both the petitioner and income tax assessee and their income tax returns have been collected during the course of investigation from the IT authority, which are available on record. However, the investigating officer has not computed the total income of the petitioner disclosed in the returns. The claim of the petitioner are correct and based on the said documents, short records. That it is also a fact that sanction was necessary. That is in addition to that. You have omitted my. I got a book.
He is not opposing.
He is
rather
supporting in front.
supporting. If you want him to oppose, then I'll issue notice. He'll file a reply.
No,
There you go.
that is their stand in the trial court.
That's what I said. There is no sanction.
No, in the
There is not-
absence of sanction that he is saying.
Sanction is also not there.
Yes.
So you have shifted the burden on me now.
Objection filed by the court below by the prosecutor.
Yes.
I am giving in support of that. I am giving a decision of the.
I'll write it here.
Much helpful.
Otherwise, again, burden. Rough draft at least I'll.
It will be much helpful for you.
Petitioner is seeking, petitioner is seeking quashing of the order dated 8/10/2024 passed by the special judge vigilance in TR case number 16 of 2021, whereby where is that order, sir? Impugn order?
Impugn order is at page.
What was that order?
That is the rejection of my application for discharge.
Whereby the application moved by the petitioner under section 262 BNSS 2023 seeking discharge from the charges, discharge from the charge offenses has been turned down. Turned down. The petitioner is one of how many accused persons are there? 2. Husband, wife, and husband, both. Petitioner, petitioners where we are the accused in the FIR number 7. So, for a commission of office and after investigation, charge sheet has been filed. When charge sheet was filed?
Charge sheet.
On 5th of the only see, charge sheet has been filed for LA's commission of offences punishable under section 13(1) E of PC Act, reduced to section 109 IPC against the petitioner. The petitioner moved an application for discharge under section which has been turned down by the order. And allegation against the petitioner are so. Petitioner is challenging the impugn order primarily on 2 grounds, namely without there being any sanction, the petitioner the prosecution proceeding with this matter. Therefore, it is completely barred under section 19 of PCA. 19 of PCA. Secondly, on merit, the petitioners submits that the prosecution in the reply to his application under section 262 BNNSS had entry stated as under para page 16 para 2. Is under सब लिखी दो ना पूरा Para 2. Para 2 of this case 6. Case 6.
Can you possibly record that the investigator has not computed the total income?
That's right. Para 2. Para 2.
Last 3 lines.
Para the highlight ko I'll just.
So, some of the file को देखने पर तो आगे डाल जाओगे.
Highlight that. Para 2. Highlighting the aforementioned 2 ground. Learned counsel for the petitioner submits that nothing otherwise in the case to be put the petitioner through trial. Hence, hence the application for discharge has been wrongly that he cannot improve his case on the facts because indeed sanction has not been taken. Sanction has not been taken in the present case. Apart from that, he also submits that the
Incomes claimed by the petitioner.
he also states that the reply filed by the vigilance before the court below cannot be disputed, and due to the specific admission by the special PP vigilance cutter in his reply to the application filed by the petitioner under 262 BNNS filed on 1st October 2024, specifically making an amendment that the income of the petitioners are genuine. Genuine and correct income. Then nothing must be add to the facts of the case. Regarding the case and Mother House India. Mother House. The counsel for the petitioner on the mentioned facts and circumstances submit that subjecting the petitioners to the rigors of the trial is destined to be trial exercise. Therefore, he relies upon the judgment of Madhav Rao. Which paragraph you are relying on? Which paragraph?
Court.
Para 7. Para 7.
Para 7.
Para 7. I'll write that. Para 7. Para 7. I am completely in agreement with the counsel for the petitioner. And this is a peculiar case where the vigilance has also not put forth opposition before the court below when an application for discharge was moved. However, by brushing aside the contention raised by both the parties, the trial court has rejected the application. For the petitioner should be discharged from the office. In view of the peculiarity of the present case, I am inclined to allow the present petition. Accordingly, impugn order is passed and the petitioner is discharged from all the offences. And it needless to say that it doesn't have a precedent. This judgment,
being based on peculiar facts and
this judgment is doesn't have a precedential value in view of the peculiarity of the present case.
If Lordship permits, may I submit one thing, Lord? In the same spirit, Lords, item 72, that is that matter of MJQ matter. Lordship wanted me to verify that Lordship judgment.
Same thing, I'll do that.
Yeah, my Lord. 72 also, when it goes in that spirit, Lord. That is a concept and physics.
He had mentioned in the morning that
desperate in fact, that's why Lord said because the spirit is there.
If you have no other matter, you can go.
But in that case, my Lord, he was the only person left out. The cost title and all the 7 minutes.
I'll change it. I'll Pass.
So 72 may be deemed to be disposed of the fashion that.
You may go if you don't have a minute.
No,
And I'm just, there is no point waiting.
in fact, there is a concept in physics that's an inertia. When the good things are going on, that in this state good in that shape moves. That's why I said it 72.
Yeah, thank you. Yes.
Well,
Yes, sir.
Please, my lord.
Yes, sir.
My lord, here, my lord, I have the for passing of the annexure 3, my lord, as because after conclusion of trial before the learned court below, believing in complainant's version, yes has been convicted the appellant under section 138 NI Act and sentenced to undergo SI for a period of 1 year and to pay 3,35,000 as compensation amount. Thereafter, this petitioner refers appeal before the learned session judge, my lord, Jagat Singhpur, my lord.
Yeah.
Whereas that in that appeal, learned session judge allowed the appeal on 29/7/21 and set aside the jail sentence passed by the learned JMFC Jagat Singhpur in 1CC case number 339 of 2015, dated 18/11/2019.
Right.
Whereas the compensation of 3,35,000 have been awarded against all the accused persons.
Sentence is set aside, compensation is maintained.
That has to be paid within 2 months of the judgment date.
Paid.
No, I have already paid that, but within not that period.
Paid. You have paid.
I have paid.
My lord, I am appearing for the informant. Matter have been amicably settled.
Then I'll set aside this order.
Yes.
I have already received the amount.
All right. Petitioner
filing the
agreed
bail
by
amount.
the order dated 21/11/2022 passed by learned SDJM. Jagat Singhpur in ICC case number 339 of 2015, whereby NBW against the petitioner has been issued. Issued. And counsel for the petitioner submits that the petitioner was convicted for the offense punishable under section 138 NI Act by order dated 18/11/2019 in ICC case number 339 of 2015, and the learned JMFC Jagat Singhpur has sentenced, how much sentence? 1 year.
Sure. 1 year.
Awarded the sentence of 1 year and directed payment of compensation of 3,35,000 to the complainant. The petitioner filed an appeal, being appeal number?
Appeal number, my lord.
Criminal appeal,
Yes.
number 40 of 2019
Yes.
to
40 of
2019 against the judgment of conviction and order of sentence passed by learned JMFC Jagat Singhpur. The appellate court, namely the district and sessions judge Jagat Singhpur, allowed the appeal partly by setting aside the sentence, setting aside the substantive sentence of 1 year SI. However, maintain the compensation amount of 3,35,000 to be paid to the complainant within a period of 2 months.
Yes.
Within a period of 2 months. The counsel for the petitioner further submits that the petitioner, although had made good the entire payment of compensation, but beyond the time frame fixed by the appellate court.
Yes.
Hence the learned JMFC Jagat Singhpur has issued NBW against him. SDJM Jagat Singhpur has issued NBW against him. Learned so entered appearance for the complainant, opposite party, and submits that indeed he has received the entire compensation amount of 3,35,000. He doesn't have any objection if the impugn order is set aside. In view of the aforementioned, the impugn order dated 21/11/2022 passed by learned SDJM Jagat Singhpur in ICC case number 1CC case number 339 of 2015 is set aside. Yes. Next.
14.
Lordship, the petitioner has preferred this CLMC against the order dated 10/5/2024 passed by the learned additional district judge,
Yes.
come special judge Bhadra in criminal division number 3 of 2019.
Yes.
Lordship, initially FIR was lodged against 4% by the informant. Subsequently, after completion of investigation, charge sheet was filed against 2 persons. 2 persons, namely Vibhuti Bhushan Senapati and Sasi Bhushan Senapati.
Yes.
Subsequently, at this stage of evidence, the informant filed a petition under section 319, wherein his petition was allowed and these 2 persons were implicated. Subsequently, were added as accused. Lordship, in the evidence of PW1, she has categorically stated that she was assaulted by Vibhuti Bhushan Senapati and Sasi Bhushan Senapati. But PW4, who happens to be the husband of the PW1,
Vidya Bhushan Damodar.
Yes, Lordship.
Yes.
He came forward and said that these 2 persons have assaulted. But wherein the informant has categorically stated she was assaulted by Vibhuti Bhushan and Sasi Bhushan. But still then the court proceeded against them. And thereafter, this revision.
But some witnesses have said that you have assaulted.
No, Lordship, only PW4.
That is the reason you have been summoned.
Lordship, but in the investigation, it has been categorically stated the present petitioner was working at a bank in Kendrapada at that moment.
That is a plea of alibi.
No, Lordship, and we have submitted all the details. And
that's right. That where have you settled? Where have you given?
Lordship, we have given all the details in the trial court, Lordship.
But some evidence has now come to light. What to do?
Lordship, may kindly have a glance at the objection, Lordship.
Yes.
And there was prior dispute between both the families.
All these things are.
Lordship, address LCR may be called for and all the details.
I just issue notice. I don't know. I don't think you can succeed here. Because see, you have a plea of alibi.
Lordship, and all the
319 is invoked because some witnesses have taken your name now. Yes. Wrong, right, whatever.
Yes, sir.
And you say that you were not there because you had a plea of alibi. That plea of alibi has to be established on record.
Lordship, both the brothers were not there.
That's right. Both of you has to establish those plea of alibi in the court.
And in the evidence also, we have already submitted.
To the police only?
In the court also. And
you
it's part of the record.
You are not the accused. How have you submitted?
Lordship, initially in the FIR, our names were there.
That's right.
Subsequently at the time.
So therefore, where is the question of submitting in the court?
Lordship, during evidence also they have stated that these 2 persons, one was working in Kendrapada and other person was working in Rourkela, and both are government employees.
But that's right. Working doesn't mean that you may not be there in the spot.
Yes, sir, Lordship.
You might be on the leave. You might have come for some purpose. Who knows? You may be working on that particular day and that particular time. You are there in the comment record. You have anything?
Yes, sir, Lordship.
Where is that?
Lordship, it's in the trial court record, Lordship. That's why LCR may be called for, Lordship. Because this person couldn't, because it's the document of the year 2006.
Because I'm issuing notice only because of the reason that they are government employee. If wrongly they are implicated, 319, they will lose their job. So that is the reason, huh? Okay. Issue notice, yes.
14.
Immediately after vacation, lagao. Yes.
Oh, bless you.
Yes.
14.
Yes, sir.
But the petitioner here shows this honorable court, section 482, challenging the order dated 26/9/2024.
Yes.
Which is a confirming order passed by the session judge of the confirming the order dated 11/4/23 passed by the learned JMFC in 1CC case where my application for sending the check for handwriting expert was duly rejected by the learned JMFC. It was again confirmed by the session judge.
Yes. Why should it be sent?
Hello?
Why should it be sent?
Manoj, but the ground stated by the petitioner is that earlier the petitioner was in a partnership firm with another person named Pawan Kumar Jain. The petitioner and both of them were in partnership firm. They were dealing with bakery products. Now they had good relations with the company. Pawan Kumar Jain had good relations with the company. Now, subsequently, the partnership firm was divided and the petitioner started his own sole proprietorship firm. Now,
What is the check amount, you tell me?
Check amount is, my lords, 4 lakhs. Check amount is 4 lakhs.
4 lakhs. You pay this amount, you are businessman.
Hello?
You pay the amount. I'll just issue notice, explore the possibility of settlement. Issue notice.
You only 100. How much?
I'll just issue notice, possibility of settlement. Don't be hopeful that I'll allow it.
My
Because it's a small amount, you are a businessman, try and give the amount and finish it up.
My lord.
That's a better idea. Okay? I'll just issue notice. I'll just come, huh? Yes.
The political is participated the scrutiny to the statement. Appeal was under the annexed 3, appeal order was annexed 3 page 18.
Confirm the order. Okay. Issue issue notice. Yes. He's not an accused.
On the grounds of no knowledge, so far the appeal memo, the grounds of the judgment is that having no knowledge. Medical experience.
Check it up.
Yes.
Check it up. Yes.
16 discuss stay of the that document, stay of the 27 document, consistent order.
What is stay? What is the order? Confiscation order, if I say what will happen? It will be released without deciding the application. It's a confiscation order. It has to be checked. Either it has to be set aside or it allowed. If I stay, what is the meaning of that? Yes.
16.
16, my lord, for the informant, I filed a wakalatnama that has not come in the list.
You are opposing?
Yes, I'm with the state.
Who is opposing?
Wakalatnama had filed in long back.
Okay. Simply urgent kodu. So and so entered appearance for opposite party. On advance notice, huh? On advance notice. Notice has not yet.
This is a fresh matter. Petitioner is not there.
Yes. Notice
Petitioner
has
is
not
not-
yet been issued. Issue notice to opposite party. So and so entered appearance on the advance notice. This is the matter for hearing. Yes. After.
70.
Yes.
May please, Your Honor.
Hmm?
Is it 16?
16.
16, yes, Your Honor, I am here.
Yes.
Wait,
16,
please,
somebody
Your
had entered appearance. He want to file objection to that.
So it's against the state, sir. Your Honor, it is against the state.
No. It's opposite party number 2, no?
I am for the informant.
Informant. He is informant. He entered appearance. And you have to implead informant.
So he was not impleted, Your Honor.
You have to implead. He is entering appearance. And petitioner is.
Your Honor, there's IA petition, Your Honor.
Need to implead informant. Tapar likhiyo issue notice. He entered appearance. Yes.
Your Honor, there is IA petition for stay of the further proceeding.
And 2-0 application, what IA? It has to be allowed or it has to be rejected. Let us see.
Yes.
Let him file the objection. Yes.
No, Your Honor, let him file, but the lower court may be stayed, Your Honor. Otherwise, warrant will be issued against me.
If warrant issue, I'll cancel it. What is the great deal? Yes.
17.
Issue notice, yes, notice, next. 19.
80. Please, your lordship. Beg pardon, my lord. Item number 18, my lord. I am praying for an adjournment, your lordship.
Adjourn on request, yes.
Grateful.
Petitioners, there are 6 petitioners. Who is the natural guardian?
1 and 2. 1 and 2.
1 and 2 are natural guardian of.
The child is now in such a home also, and elected in another boy also. Once protectment recorded. Agreement now she was staying in such a home also. Now the present person's parents and other family, police I did not go to the now court to production to take the her minor daughter.
Okay. So what do you say? 183.
One student who is not with me for the time being, but
What are the allegations? What are the allegations?
That accused person, we filed the expert before the Supreme Court and granted the entry order. And in that entry order, this Honorable Court directed that petitioner to produce that
Well.
for the court below for reducing statement order 164.
And thereafter she was kept in that. Where is that anticipated bail application? Show me.
We have not attested, but
I know you tell. Show me where have you said that those things.
anticipated bail, you
Where
know,
section 2, the 30 years of time now. 183 on the day kept the root cover, the 160 protected recorded. And it was
But she is a victim girl.
yes, yes,
They want to. The parents want to take. Why should she will stay in the remand home?
yes, your lordship.
But my responsibility is 164 technique. He stated that by not checking my parents, that may cause prejudice.
She is a minor.
Yes, that
She is a minor.
Yes, that is the regular.
Then the minor she is, you have to. Shall I allow it?
Yes.
Or you want to seek instruction? I'll pass it over.
The 164 technique record by the So you have to know how
24th.
Yes, sir.
Don't delay because
Yes, sir.
and 24th morning if I can't take, you just mention it.
Yes.
I'll allow it. Yes. Yes.
20 when meantime the petition will be allowed to be visited.
IA has been filed here.
Visiting. Okay. Okay. Where is the IA? Yes, IA. Petitioners are aggrieved by item 19. Petitioners are aggrieved by the order dated. Where is that order? 18/11/2024, passed by JMFC City, Baleshwar, in city case number 677 of 2024, arising out of PS case number 404 of 2000, Baleshwar PS case number 2024. What is partial modification?
That order, in that order, the direction was given to the court below to keep that lady in that victim guard in a short room. But that I find it was not personal modification of this order.
The whole problem is in the petition you don't write anything. One order you file, everything I have to connect, and everything you will tell in orally. Where have you said all these things? Still difficult to. So whereby the application of the petitioner for handing over the custody for the victim girl to the parents have been rejected. Rejected. Issue notice to opposite parties also. The the petitioner being the natural guardian and the relative of the victim girl have moved the present application seeking to meet the victim girl in the who is in the short stay home. Where is that? What is it? Where it is?
Before the added is before President
application is allowed. The petitioners are allowed to have a visitation right to the victim girl who is in custody. Who is at present at Nari Sangho Baleswar. Okay. You bring those application, the application which you have moved, and the other documents also. You please file. What is this? Only one application, only impugn order, nothing else. Yes.
We pray for an adjournment, Your Lordship, after the meeting.
20.
It's actually yesterday night I received the information the matter is going to be amicably settled. That's
What are you seeking, by the way? Yes. Okay. Okay.
Let it come after vacation.
Yes, after vacation. On request. On request.
21. Case appeal, arraigned for 3 years.
Same order for the appeal admitted, bail granted, realization of a fine paid, and call for TRC and lease the matter after the TRC is received. Mr. Sanjay Das appearance and all. Yes. Yes. Yes.
22. 3 years. 3 years. Case appeal.
Same order. Huh? Same order. Yes. Stay. Yes.
23. 23 is in custody 4 years.
4 years.
He is in custody from the date of judgment.
Release on bail. And release on bail. He is in custody. Release on bail. और बाकी सब stay सब करो. ठीक है.
24 also 4 years. He is in custody. Judicial custody.
Release on bail. 23, 24 release on bail. Realization of fine states. No. Yes.
And all the 3 copies be done.
Yes.
May I pray before you accorded me by the item 61. I will have to get myself prepared. There Mr. Paddy's case, Prasanna Paddy, that secretary purchase of land. So I could not prepare myself because of the pending case. Yesterday 2 matters were there.
You want an adjournment?
Yes, 61 item.
Note
I will have to prepare myself for that secretary. Your Lordship has found out that why secretary will be liable.
Yes.
President.
That matter you want an adjournment?
Yes.
I mean it.
According to me after vacation, any date.
Note कर रख दियो. ठीक.
Hon'Ble.
25. My lord, I am appearing on behalf of the petitioner, my lord. I am on
Yes.
BC.
Yes, sir.
My
Yes.
lord, before today, Mr. Nayak is also there. And my lord, before taking your lordship to the merits of the case, my lord, I would be citing 3 judgments of the Honorable Supreme Court and High Court.
Now, what is this matter? Let me understand what is this matter is about.
My lord, this is in regard to the release of the cash amount that CBI has seized after arresting the petitioner and thereafter from his office and entangled him in 12 years ago. What has happened with the new currency notes found in his office, and that is his mother's treatment money along with the others which has been given accounted for. Now, my lord, kindly I would ask Mr. Behra, my learned advocate on record, Vasaba Kom, Manjit Singh and Sundar Bhai Lal Ambal Lal Desai to be placed before your lordship. For Mr. Nayak, I would be also citing the judgments 1977 4 SCC
Yes.
358
Para?
para 4.
Para 4. Yes, read it.
My lord.
Yes.
The object and scheme of various provision of the code appeared to be that where the property which has been the subject matter of an offense is seized by the police is ought not to be retained in the custody of the court or the police for any time longer than that is absolutely necessary. As the seizure of the property by the police amounts to a clear entrustment of the property to a government servant, the idea is that the property should be restored to the original owner after the necessity to retain ceases. My lord, I shall read till here because the rest of the disposal of the property, as everybody knows, my lord, 450.
Yes. Next judgment. 2014.
Then, my lord,
2014.
Yes, my lord.
Manjit Singh. Which paragraph?
My lord, para 65, my lord, regarding the currency notes.
65.
My lord.
Yes. Yes.
The note seized by the may be released to the person who, in the opinion of the court, is lawfully entitled
Currency seized. Be
after
released.
detailed Panchanama, taking photographs of the currency note and taking a security bond, my lord. Then, my lord, we come to the next one. Sundarbhai Ambalal Desai versus the state of Gujarat, my lord. This is the case. It has been time and again, my lord, affirmed by the Honorable Supreme Court and other courts while delivering judgment on this type of matters, my lord. My lord, paragraph 8, my lord.
And 19 also.
Citation. What is the citation, sir?
The citation is
2002 10 ACC.
Page
283.
Yes.
Sir, which page?
288.
And in this case, the Basava is noted.
Yes, Basava is noted.
Yes. Yes, I got it. You tell me now.
Now, my lord, my respectful submission, my lord. This is not a confiscation proceedings, my lord. That money has been seized.
Okay. Yes, Mr. Naik.
Your Lordship, may kindly come to.
What do you say?
Your Lordship, may kindly come to 457 CRPC for a moment.
Let them cover up by giving some security. Finish it up.
Oh, Your Lordship, this 15 lakh rupees is from the proceeds of the crime, Your Lordships. The Supreme Court has told at that point of time that you particularly go after the money trail part. Your Lordships, 2014 volume 8 SEC, page 768, para 34, I would like to quote.
Yes.
The direction from the Supreme Court to go into the money trail part. And Supreme Court has also directed that ED will also go after them. Your Lordship, let me
Which
read
judge? Have you filed those judgments?
The Subrat Chatura judgment, para 38. 2014 volume 8 SEC, page 768. Lordships,
Yes.
a small judgment. While we do not consider it necessary to go into the question whether the state police have done well, it ought to have been done. We need to point out that the money trail has not yet been traced. The collection made from the public far exceeds the visible investment that the investigating agency have till now identified. So also the larger conspiracy angle in the state of Assam. Now, Your Lordships may kindly come to the averment made by him. Lordships, page 13, para 13, page 8, he's saying that the cash part is not mentioned in the charge sheet. But Your Lordships, when we seized his account, in his personal account, Your Lordships, the money which is from the proceeds of the crime has been transferred. He's saying that the money which I have collected from the depositors, which is illegal money, you kindly give it to me. Then he will dispose it of, Your Lordships. These are from the proceeds of the crime, and Supreme Court has categorically stated that you take that money trail part, keep those money with you so that it can be returned back to the investor. He is saying that the money which he has collected.
Where is that in Supreme Court's judgment? Which part of the judgment?
Lordship, para 38, Your Lordships.
Para 38 of what?
2014 volume 8 SEC, page 768, Subrat Chatura judgment.
2014?
Volume 8 SEC, page 768.
Where is that judgment?
We need to point out that money trail has not been
Hey,
traced.
where is that judgment? You give that judgment. I don't remember.
And I'll file it, Your Lordship. I'll file that judgment.
Give that judgment. When have you seized this money, cash?
Cash, Your Lordship, it has been seized as item number 4 in the seizure list.
When have you done that?
It is in the year 2022, my lord.
And if it is
Yes,
the proceeds of the crime, have you identified whose money is that?
Lord.
Yes,
Whom
Lordship,
do
he
you
could
want
not
to give
account for.
it?
Your Lordships, this money is from the proceeds of the crime.
How can you say
Because
that?
in the charge, just 1 minute. Your Lordships, we have filed a charge sheet. Your Lordships may kindly come to para 16.48 of the charge sheet.
Yes. Charge sheet.
Charge sheet para
Yes.
16.48.
16.48. Yes.
Charge sheet, your Lordship starts. Lordship has a copy of the charge sheet?
16 point, how much?
48.
48. 16.48. Yes.
Lordship, I would like to
Yes.
read that paragraph.
Yes. Investigation further discloses.
May I read it, your Lordships? Investigation further discloses that out of the money collected, that is in crores, appropriated by Lakshman Srinivasan, he paid 29 lakhs to Uttam Munshi for his purported deal as a share. The rest amount was directly misappropriated by Lakshman himself by way of making cash withdrawal. Now he's saying that this money belongs to my wife, my mother. There is a finding in the charge sheet, your Lordship. This is from the proceeds of the crime, from the investigation, your Lordships. Transferring into the accounts of his family members and also into the accounts of other society, which he claimed as his professional fee deal. Whereas the brokerage was found to be more than actual money given to the owner of Ashok Nagar Society, Lakshman Srinivasan could not produce any bona fide documents in support of his fees, if any, under IRL or Sri Sopan Kumar De and society by way of entering into an agreement or MOU.
Now,
Therefore,
that
your Lordship,
15
he has
lakhs,
misappropriated
regarding that 15 lakhs, the charge sheet deals with that 15 lakhs.
the 15 lakhs is
Basically,
this proceeds of the
that
crime on, your Lordships. This 15 lakh is the money which is from the proceeds of the crime because he has withdrawn cash from his wife. He is saying that, your Lordship, may kindly read it again. Investigation
I saw that. I saw that.
directly misappropriated by making cash withdrawal, transferring the account for
Let
his
him,
family
okay,
members.
let him give bank guarantee. Give bank guarantee.
My lord, I shall be giving the appropriate, my lord, bank guarantee, Lordship. If that is given, then 15 lakhs has to be put in and then 15 lakhs has to be come.
Yes.
Owner's liability, my lord, kindly sees.
So what? No. What he says is it's the proceeds of crime, and this money has to be disbursed to the victims. So therefore, it can't be
That
returned.
is the
That's
direction
what
of the
he says.
Supreme Court.
On the
That is
direction of
also
the Supreme
direction.
Court.
Lord,
Yes.
kindly note the submission of Mr. Nayak, my lord, and my lord disposes of according to your lordship's discretion, my lord. I shall not stand in the way. My lord, according to the onerous conditions, Honorable Supreme Court is very clear. And my lord, any money which has not been a proceed of confiscation, where there is nothing, presumption of innocence is in my favor, my lord.
That's right. You're there.
In
But
that-
where, Mr. Naik, show me that Supreme Court judgment. What you are saying?
Then your Lordship, the amount, your Lordship, then the plus one.
regarding fund.
Your Lordship, then when the
My lord, he was
Yes.
not in the
Let him
FIR.
argue.
He has not been named in the FIR. He is a consultant, a professional. His mother's money, mother has given the certificate from the pension account, my
There
lord.
is a finding. Yes.
She
Yes, your
is
Lordship, there is a finding. There is a finding in the charge sheet that he was misappropriating money in the name of the family members. There is a finding in the charge sheet.
That is the
And your
opinion.
Lordship, moreover, just 1
Now
minute. Your Lordship,
show me that Supreme Court judgment where it says it has to be disbursed. Show me that judgment. That's all. I'll pass
disbursed.
the
The
order.
court has not said that it has to be disbursed. The court has said that you go after the money trail part.
The money trail is
Your
another.
Lordship, let him pay 15.
He will covered. He will covered by some guarantee.
No, let him pay 15 lakhs bank guarantee, your Lordships.
Bank guarantee, why are not other guarantees? My lord, the security, local security, my lord. My lord, this
Your Lordships, I'll give a hypothetical example, your Lordships. Lordships, just 1 minute. Your Lordship, if
See,
somebody
these are
has
the
collected
matters. See, these are the matters shouldn't take more than 2 minutes. You
Your
give me
Lordship,
that
somebody will
judgment, I'll pass that order.
Your Lordships, if somebody will give, if somebody will collect 100 crores from the proceeds of the crime, he'll say that you give me before
You know,
investigation.
it need not be analyzed. It need not be analyzed. It's a small matter. Give me that Supreme Court judgment. I'll pass the order. Where is that judgment?
Yes, your Lordships.
You are relying upon
Yes.
some judgment. You give me that judgment. He has relied upon 3 judgment. You give one more, whatever you want to give. I'll
Your Lordship,
deal
may
with
record by
that.
some. Yes,
You do have your junior. Do you have that with you?
copy of the judgment right now, but the same paragraph has been reproduced in para 14 of the counter here.
No, I need the judgment. The related paragraph also I have to
During the
read.
course of the day.
Sir, Bunny
Para
Trail,
14 and Subrata Chatra judgment also I'll give your lordships.
Bunny Trail.
Why are you not bringing the judgment? I don't know. These are the matters to be heard for 10 minutes, 20 minutes.
Lord, actually,
Place it immediately outside.
that's always the submission.
Get the judgment, Mr. Naik.
But sir, he
You
has
should be
also-
ready
your
with the
lordship, I
judgment.
have-
You are citing, you are relying upon some judgment. You should be ready with that.
Your lordship, one more. Your
20
lordship,
minutes
he
I
has-
have wasted in small matter. Huh?
Your lordship, he has given me 3 judgments. He has not given me. Let me examine those judgments also. Your lordship, fix a date. The
Citation will
judgments which he's
Fix a date. Yes. I don't want to waste
yes.
time. Yes.
26.
Lordship, fix a date. Your lordships.
So that is their idea of getting a date from the very last date they were doing this.
Okay, you give judgment. The judgment को copy रखो उसमें. Take the citation from here. Take the citation. And it's made clear that no further adjournment shall be granted at any cost.
After 10 January, any date. Lordship, after 10
Small
January.
matter. It's a small matter. It can be disposed of. What is the big deal? Yes.
Okay.
Yes. Sir.
After 10 January, your lordships.
Yes. He'll give it. Yes. Next. Yes, sir.
Milord, my submissions are already concluded, Milord. I have nothing to submit.
Yes, I understood it. Yes, Mrs. Sinha, I understood it. I just. Yes.
And which person was given bail by the Honorable Supreme Court, your lordship will see that is on record that I have put in. What was there are two.
It's all right. I'll hear it now. Yes.
Yes.
I'm somewhere else.
I'm
Where is that?
26.
We are in 26 now. 17. Don't mention in between. Yes, 26.
That is in the year 2004, a land acquisition notification was issued for acquisition of land. While the petitioner received notice by the land acquisition authorities, appeared and produced the documents. The compensation was estimated, and it was disbursed on executing a bond by the petitioner to the effect that if any dispute arises in future, he will deposit the entire amount. After a lapse of 1.5 years, again I received the notice from the land acquisition officer that a rival claim has come. I appeared before the authority. Authority said, same name, parentage, age, address, there is another person who lays his claim. You deposit the amount. Then and there I deposit the amount, my lord.
So what happened there?
The charge sheet has been submitted against me. So what is the matter? I have not cheated anything or I have misappropriated anything.
I've gone through the entire petition. Lordship, turn to the appendix 1, the first page. That 7 line I may permit to place.
Notice part? Notice. Notice, you are talking about notice.
That's synopsis.
Synopsis. Okay.
Lords, I'm placing that 7 lines per
okay.
The petitioner so and so, Lords. Lords, you can see the name, father's name, and the place of residence also same.
Yes.
He received a notice from the land acquisition officer from Land Sankar Jagsimpur in his residential address. He produced certified copy to the land records relating to the scheduled land. On the basis of the same amount was passed and compensation was released on education a bond for refund of the whole amount in the event of a dispute arise. After a long lapse of time, he again received a letter from the lands collector that there was another person in the same name and identity, in the father's name and the residence and same another person is there, who laid his claim over the lands. The present petition was not noticed. The petitioner to come to know from the authority deposited the entire amount. So there is no pecuniary loss prima facie. This is my opinion.
He had given an indemnity bond. If anybody comes, I'll pay. Somebody came, he paid, finish.
Suppose I received my postman's I received.
You are Sangram Das.
You commented.
Your father's name and everything is there. You have taken money.
Got the money.
Given an undertaking.
And got the second letter after a few days. That no, this is another same person, same residence. Then I paid back. So that is the factum of the pecuniary loss is absent.
I don't think it. I'll pass it. Right. Petitioner in this petition.
My formal objection was recorded.
Yes, definitely. In the petition, the petitioner has assailed the petitioner in the present petition seeking passing of court. What is it? You said impugn order. What is the impugn order?
My lord, the rejection of my application for discharge.
You moved an application, huh?
My lord.
Petitioner is agreed by the order dated. But there are so many accused.
No, no, I'm for one. I think that is that serial number 3.
What about the other accused? What are the allegations against them?
Those I cannot see.
The land action of another person died, my lords. This is what.
No, but the implication has to be seen. Where is the charge sheet? Where is the charge sheet? Sir, show me the charge sheet. You have to file charge sheet.
No, no, I have not filed that.
You have to file it. On the basis of pleading, how can I?
The lordship will fix a date, Mullah, on the first week of.
First week. Issue notice?
Short date, Mullah, first week.
Yes. You file the charge sheet so that at least we can see what are the, because see, once I pass it, the other accused person, they may have something, they'll say that it has been passed for someone.
Lordship correct.
Yes, that's the problem. Yes. Otherwise, you don't have a case. Otherwise, they don't have a case.
If lordship permits me another thing, my learned friends come back from another court.
72, he has,
in the light of that.
He is so scared that he is conceding.
No, in fact, he's a very sincere guy. In fact,
I'll allow it.
And he's a worthy son of a worthy father, and all are in district judges, my lords. And he's a very sincere person, my lords. And I've gone through his petition, my lords. This judgment is lordship part is the one person left out, my lord.
I'll allow it. I'll allow it.
I'm obliged to my friend.
And he told in the morning, I said that you can also leave and you are free now. I'll do that. 72 October. Yes.
27. So far the petitioner is concerned, I have given a description at paragraph 5 of my revision.
So many officers are there in that excise offices. The concerned file was routed through notes. He was the person who gave the allegations
What
that.
was his designation at the time of alleged incident?
That's required for this.
But by the way, have you challenged that in the Supreme Court? No?
He will go to Supreme Court. He lordship knows that Supreme Court the best, the foundation of the High Court judgment and then the Supreme Court. How can you go?
No, when the foundation has been broken, then how the structure will remain?
Right.
Because that is your lordship has. I have gone through your lordship's judgment because your lordship has not considered the individual allegation order. Your lordship has considered the broad probability that this is the basis on which the prosecution has emanated. And when that has already been
caused by the everything collapsed. That's the idea.
That is the whole thing your lordship has described in the judgment.
Okay, thank you.
Thank you.
72 दे दो. Yeah. File दे दो.
27.
20th May 13. Bail. You are on bail. 5 of you are there. Then you pay 1,000 each. 2013.
Each person's they have paid 1,000 in another.
They are doing this kind of thing in the 2013, the NVW, and let them pay to District Court Bar Association. District Court Bar Association. Kora put to District Court. Yes. Pass. I'm giving 10th of January. Okay. Yes. 28.
The petitioner has filed bail application under section 482 of CRPC.
Tell me.
Bail granted on 23rd July 2020 and NBW issued 1st September 2023.
2020.
2020 bail was granted.
20,000. Sorry, 22,000. 1,000. 1,000. NBW के पहला 2023. 500.
1923.
500. Yes, 500. Yes. Next.
29.
29 on September 21 bail was granted. On 13 September 2023 NBW
500. Yes.
12 May 2022 bail granted and 16 November 2024 NBW
500. Yes.
31.
31 not bail.
Bail. I have copy, my lord. Bail.
There's a date type.
5/10/2023, my lord.
5/10/2023 bill.
NBW
NBW
29 November.
11/2024. 500. Yes.
32 on 1st February 2024 bail granted. 24 September 2024 NBW issue.
Okay, 500.
That is the 1st March 20.
Yes. You tell me when you got the bail. 15/5/2024 NBW bail.
Bail
23.
1st May
22, 23, 24. You tell the year.
bail के खिलाफ first March 2023 bail.
Mr. We shall write these two dates I need.
Yes, my lord.
What are you researching? I don't know. You need the judgment or what?
No,
Supreme
no.
Court judgment.
1st March 2023 bail and NBW issued 15 June 2024.
500. Yes.
34.
Yes.
36 2005. 26 2024.
500 is
34. 34.
500 is
Number 34. Item 34.
500 is. Huh?
28 to 2020.
Bail. You tell me, sir, you don't argue with him. Tell me dates. Why are you wasting time?
35 bail is 23/195. NBW is 26/4/22.
22. 500. Yes.
Lordship, also item number 34, he was on bail on 1/7/2016.
Agree.
And NBW was issued on 28/1/20.
20, yeah?
His
1
wrong facts, Your Lordship. Was
Yes.
there. Wrong, bhul po chalo. 36.
To date also you are not able to cull out from the file.
Date has
What kind of assistance I don't know. Yes.
The accused entered into appearance, filed an affidavit, assured that I will pay the
What is, tell me the dates.
My lord, the renewal has been issued since 29/7/2024, my lord.
Petitioner is an accused in the complaint initiated by opposite party for the offence under section 138 NI Act. Due to the non-appearance of the petitioner on date
My lord, that is on 29/7/2024.
NBW has been issued. Sorry, yes. 500. 500. Yes.
37.
Yes. Yes. 500. Local bar. Yes. Today all local bar control. Local bar.
38. Hello. Is 18 individual and issued. It is mentioned for complement of the area maintenance matter.
NBW has been issued against the petitioner for default in payment of the maintenance award. Maintenance awarded in favor of the petitioners in favor of the opposite party. Yeah? Number 2. Opposite party number 2. Wide order dated 30/10/2023. For the 31st December. 31st December and stay till 31st December. Yes. Stay till 31st December. You go and appear. Yes.
39. Since 27th December 2021, NBW was issued on 2024.
500 each.
40.
Or 34 the 10 January. Yes.
40. Lord, NBW on 28/8/23. Bail is on 36/2005.
500. Yes.
41. NBW was granted on 25/4/2012. NBW is on 29/11/2022.
500 each. Local bar, huh? Local, Khurda.
42. 17 for 2020.
2007?
Why can't you speak little louder? Hmm.
And NBW on 29/7/24.
500.
Here.
Yes.
Bail order date.
23.
NBW issued on 26/9/2016.
हाँ.
The bail is not mentioned.
Bail.
Bail order date का more.
You are on bail कर दिया. ठीक है. 2016.
2016.
Pay 3,000. Yes. 2000.
44 he was on bail 22/5/2017. 317 petition was rejected.
NBW issued on
NBW issued 28/11/2019.
1000. 2000. 2000. Local bar, huh? Local bar. Yes. 2000. These are 2000. Yes.
45.
In 5 there is CORAM. And he is also
My lord, in this case,
who affidavit to evidence evidence of witness is also not supplied to
8
and 9.
My lord, I have filed the deposition copy of 8 witnesses.
But you haven't supplied to the state council. Supply. What are the offences?
302-201. My lord, the accused who was found
302-201.
Council for the state submits that the deposition copy which has been filed and relied upon by the petitioner has not been supplied to him. The petitioner is directed to supply the copy of the deposition which has been filed on record. Release the matter. Yes.
obliged, my lord.
May I please? Here, my lord, the present petitioners, my lord, I am appealing the sub-item, my lord.
I am appealing in the another 2 matters, your lordship. Your lordship previously heard this matter, my lord. 3 petitioner before your lordship. My lord, the contraband article seized is 154.400 kg, my lord. Each contain, my lord, 38 kg 600 gram, my lord. Your lordship, the present petitioner are in
Custody.
Custody is 19/5/2023, my lord.
Yes. Yes, Mr. Jana.
My lord, your lordship has called for a report from the Law and Trial Court. And also, your lordship has directed me to obtain instruction about the antecedent. There is no antecedent. This is the instruction, my lord.
No antecedent. But what is the report?
And they are the outsiders, man.
They're outsiders.
Well, so far the sub-item is concerned, is the local person 19-year boy, my lord.
1 minute. Whenever I call for report, press the report.
File Q.
13.
File Q.
File Q.
My lord. Noting is there.
Q. Q. Okay. When was the order?
It is, my lord.
Where is the report? Q is not the report. Q is not the report.
Noting
Report is not there.
your lordship, the flag Q is the report, my lord. The learned court below stated.
My lord wants
No
when
witness
plus
is
1 for.
Report is report is not there. No? Pursuant to the order dated 13/11/2024, or the fresh report sought from the court below has not yet been received. Accordingly, the trial court is directed to furnish a fresh report regarding the status of the trial. We see matter in the first legal. Yes, next. Yes.
May please, Your Lordship.
47.
May please, Your Lordship. The petitioner, a year-old lady, she is in custody since 22 to 2024.
22?
To 2024, 22 February, 22nd
Yes.
February.
Yes.
The charge sheet already submitted on 27/3/2024. This is a dispute between mother-in-law and the daughter-in-law, Your Lordship. On the
Mother-in-law?
And daughter-in-law.
No, you are for whom?
I am for the mother-in-law. Mother-in-law is the sole accused in this case.
Hey, is there two petitions?
No, no, no.
No, Your Lordship, there is
But the daughter-in-law is the
sole SCP is daughter-in-law. The victim is daughter-in-law. Yes,
Okay.
stated one statement that they will SCP indict more.
Yes, so 164.
Yes, Your Lordship. Your Lordship,
You are appearing for?
That is in front of my lord.
Yes.
In view of the notice, I appeared my lord.
Your Lordship,
Earlier they also assaulted the in front of my lord. That is in 2019, my lord. Wherein the infant is also medically examined and that was a settled, my lord. Again, my lord. This is
Your Lordship,
apparent.
the
If she
case
will-
is such that on that fateful day, the petitioner threw some liquid to the informant, which she stated to be acid. But on the, Your Lordship, kindly visualize the situation on the FIR dated, FIR on the
No,
given.
come to the medical document.
Your Lordship, page 15, Your Lordship, the medical report, the injury is simple. On the very same date, the incident occurred at 12:30 p.m. and the informant hospital presented the FIR at 6 p.m. on the same day, which shows that there is no injury, otherwise simple injury, as per the medical report, Your Lordship. She is in custody.
What is that acid? What is that acid?
That home use acid, they had no prior preparation. On the spot of the moment, she threw some liquid.
Yes, what have you recovered from the spot?
The toilet liquid is the acid.
That has been thrown by the
Yes, yes. What do you say?
I also filed affidavit, my lord. Annexed one document, my lord. Earlier that in the on 5/11/19, she was also assaulted by the petitioner, my lord. And that was settled between the parties at a police station. And there was the injury body there, my lord. And
That is-
subsequently,
In this case, it's simply injury. She has not brought acid for the purpose of killing. Oh, this was lying in the toilet, is thrown out of
Then
this.
once
They
the-
don't have a good relationship, what to do? But and she is already there from February. How many years will keep him? To 326.
any stringent condition, my lord, because
Yes.
she is in again come to
You
the
are
house.
staying in the same house or somewhere else?
Same locality, my lord.
Locality.
Go to the-
What condition you want?
My lord, imposing because it is
You tell me what condition you want, I'll incorporate. As simple as that. You tell me what condition, whatever condition you want, you tell me, I'll incorporate that. Tell me.
still not harass the again not is not moving the locality, my lord.
I shall give bail.
Because again such is the second time.
How can I restrict him her movement?
House arrest.
House arrest. I'll give him from the jail and put it.
In my house, the informant is staying.
Any condition, any.
Minor as imposed, my lord.
Right. I don't petition on the accused is also okay. Allegation against the petitioner is also. The petitioner is the mother-in-law of the victim. Mother-in-law of the victim. He has been in custody since 22 to 2020. What is his? He is 62 years. Is okay. The from the medical recorded medical report, injury report, placed on record, it reveals that the injury sustained by the victim is simple in nature. It appears that the petitioner has used the acid kept for using in the toilet, using in the toilet, and thrown it on the body of the victim, which caused the injury. allegation regarding to the facts that the petitioner is a senior citizen, petitioner 62-year-old, and she is in custody since 22 to 2024. And charge has already been filed on 27/3/2024. I'm inclined to enlarge the petition on bail with condition. Condition he shall not in any way whatsoever be in contact with the victim. Yes.
Clear. Much clear.
48. Item 48, may it please your lordship. On last occasion, your lordship had directed the learned state counsel to obtain instruction on the basis of the additional documents filed.
Yes.
I'm seeking for the regular bail, your lordship. I've been in custody since 6 March 24.
Lordship, the amount of investment 3 crores or 75 crores. Then you notice a constable. Last lordship, while at the time of hearing, lordship, keep in mind for the bank, the president, the manager of the bank, is used the public money and directed to deposit also. To that part, you have to keep in mind for a bail or I am interested that the bank.
Yes.
Lordship, on the basis of the allegations they are stating, the total amount is coming approx about 4 crores, your lordship. Because, let me complete. Because they had, as per the complainant's version, they had, the complainant is stating that the BDO has given total 7 yourself checks for the opening of the flexi fixed deposit account. As per the, on the basis of the additional documents at page number 60, your lordship, we had sought an RTA application on the basis from 2014 till 2024, where the BDO has been posted at the PPL block. The BDO who is being asking for the flexi fixed deposit is not the same BDO who had earlier opened the bank account before the concerned branch, your lordship. The BDO asking for the flexi fixed deposit is different, your lordship. And on the basis of that, the bail application was also rejected by the Honorable OPID court on.
You are the BDO for which period?
I was the co-accused. I'm the co-accused. I was the asset officer, customer relationship manager, your lordship. Whatever the.
Have you verified the document which you filed? No. Last time I said that you verify. He has relied upon certain document, set of documents. I told that you should verify. The last order. In view of the additional document, place the learned counsel for the petitioner in the file. The learned counsel for the state seeks an adjournment to obtain instruction in that regard. You simply tell whether you got instruction in the light of the document submitted.
I have verified, your lordship. The ID number is so and so. The 174 is the ID, employee ID of the present petitioner, lordship. From the said ID, the same petitioner has transferred the said 3.some crores amount to the different accounts, lordship. You have to.
Two accounts number. I am for the bank, my lord. I am stated in my objection, my lord, page number 5, my lord, clearly stated that the present petitioners, 2 accounts are open in the name of the one father and another is the mother of the present petitioner, my lord. Through 2 accounts, 37 fraudulent, the money transaction.
How much transferred to these 2 accounts?
That's not that I am need to.
What is the amount transferred to these 2 accounts, mother and father?
The document.
Para 7, come to para 7 of your objection. You have filed the objection, you have not read it.
Yes, my lord.
Come to para 7 of your objection.
Sorry, man.
At least you read your objection. Don't read their paper, you read your paper.
Yes, sir.
Para 7.
3.7 crores, my lord.
And 35 fixed years loan.
To the 35 fixation loans, my lord.
3.7 crores you have transferred.
Your lordship, I was serving as an assistant manager. All the
my lord.
They are saying,
but the assistant, the asset officer, Tanmay Kumar Marana, that is you, had transferred the entire amount of 3.7 crores to 35 fictitious.
Your lordship, may I be permitted to have a glance at the annexure to page 25 of the main petition? They had conducted, as per the instruction of the executive director, they had conducted an staff accountability examination report. On the basis of that, they have stated that the allegation which they are stating about misappropriation of 3.7 crore is against the main branch manager who is the main accused in this case. It is at running page number 25, main petition, your lordship.
25. That is the FIR.
No, your lordship, it is staff accountability report. FIR is at page number 20, annexure 1 of the main petition.
20 main petition only.
Main petition,
It
page number.
starts from, you have said that. FIR starts from page 19.
Page 19.
No, that page, all the pages are not paging the copy as
You are referring to which page?
given by the present petitioner.
Referring to which page?
Referring to page number 25, annexure 2.
25, yes. Okay. Annexure?
Page 25.
Annexure 2 starts from 54.
Your lordship, that is on the basis of the. I'm relying on
The first annexure is 19 to 53. Second annexure starts from 54 to 61.
Just your lordship, 2 minutes, sir.
Get your paper ready. Next, after immediate after that. Yes. Next.
49.
Yes.
In the meantime, charge sheet has already been submitted. 3 of the 4 are those who have been apprehended on the spot and the confession of court. The present petitioner has been submitted. Basing upon the confessional statement of the court. 3% they have been granted. Charge sheet submitted.
Mithu Digal. So, yes.
3%.
Yes, Mr. Mohanty, what is the allegation against?
Contraband ganja also.
Huh?
But 73 kilos of ganja.
73.
Yes, sir.
Oh,
73.
granted.
Yes.
73 and conscious possession is not there.
I have just now received the copy of the order lordship and this circumstance they have released. that.
Show me, you.
I have handed over.
No, this is co-accused.
Co-accused.
You stand in the same footing, just see.
My lord.
Alok Digal.
The person those who have been named Brusabakar and Milu Digal, from whose person that property has been seized. Brusabakar and Milu Digal. They were apprehended at the spot.
Petitioner is accused and so on, so on, so on. Allegation. I read you the co-accused persons, namely the principal co-accused persons, namely Milu Digal and Brusava Conver, from whose possession the contraband ganja of 73 kg had been recovered, had applied for bail by filing BLAPL number 6438 of 24 and 6237 of 2024. This court by order dated by separate order dated 4/10/2024 allowed their bail fee and enlarged them on bail, admitted to them on bail. Subsequently, the co-accused Shamsan Digal had also moved bail moved BLAPL number 11210 of 2024. The said application has also been allowed by this court by the order dated 4/12/2024. Petitioner is seeking parity with the co-accused person. Submits that. Yes.
The present petition having two similar nature of antecedent laws. Those persons who were granted bail, whether they have any antecedent that part.
That is to be verified.
I will just pass this order, let him do whatever. He will, at least his job is done. There I will see. Same standard condition. And the trial court will not release, then he'll move application. Then we'll see. Then we'll see. At least today, at least he should get the bail. Right. Siddharth and counsel for the petitioner submits that from the position of the petitioner, no contraband has been recovered. Rather, on the basis of the confessional statement of the co-accused, he has been implicated in the present case, and the co-accused, those who have given disclosure statement to the police, has already been enlarged on bail. Hence, I'm inclined to
oblige it.
Same condition, similar case on that. Yes.
Your lordship, at item number 48, the main petition is running.
48 adjourned.
Adjourned.
50.
My lord, petition custody in since 18/3/2024. 18/3/2024. And alleged offencer registered under section 30234 IPC, but charge sheet submitted On 302 120B 34 rupees.
302
to 120B 34
Yes.
rupees. Which one do you want?
Yes. What are the allegations? Have you got it? Any?
No, nothing.
Who all are the
Actual principal actor is Sunil Digal, my lord.
Sunil Digal?
Sunil Digal. Page 90, kindly see page 91, my lord. Sunil Digal is main accused.
Any eyewitness? Any?
Only thing is,
One thing is that this accused person arrange a meeting, village meeting.
No.
To kill this.
No. Actually, Sunil Digal.
And his wife. The suspecting that witchcraft they are
Where? Whose evidence is there?
from the 164 statement
Oh,
of the informant.
informant. Only informant.
He has said nothing. He said,
wait, let us understand first of all. Yes.
Informant.
Informant.
Is the son of the district.
Para 5 रे कहिছে देखो ना my father is a priest of goddess Boralogy.
So let him complete the sentence at least.
My lord.
Wait, if this is no way of arguing, somebody is arguing, let him complete.
Doctor, at the 164 statement and 45 witnesses are there. My lord friend had supplied only 4.
4 witness examination ଯେତିକି ସେତିକି କିଛି
ଗତ 8/3/2024 ମୋ ବାପା ମାଙ୍କର ମୃତ୍ୟୁ ହୋଇଲା। ମୋ ବାପା ମା ଗହିରଟି ଗାଁର ରହୁଥିଲେ। ଚାଷ କାମ କରିବା ପାଇଁ ସେ ମୋ ବାପା ପ୍ରତ୍ୟେକ ଗୁରୁବାର ଦିନ ହରଳା ଦେବୀ ପୂଜା କରେ। ମୋ ବାପା 7/3/2024 ସକାଳେ ଯାଇଥିଲେ ଗୁମାଲ ଦାନୀକୁ ପୂଜା କରିବା
69/2023 and 90
16/9/2023.
Yes.
No criminal incidents, my lord, and no exclusive.
What is the recovery?
155 kg guns. And lordship had called for the status report from the lower court.
Now for recording of evidence is fixed on 22nd. 22nd. For 22nd, the persons to the order dated 13 persons to the order dated 4/12/2024. The district judge Gajapati has submitted a report into India stating that although the charge has been framed on 28/3/2024, but the recording of evidence has not yet been commenced. The case is now fixed for recording of evidence on 22/1/2025. 2025. This matter. This matter. Next, let us see who all are examined. Right? The trial court is directed to examine the vital. Who all are the vital witnesses?
No witness, no independent witness. Your lordship may kindly see page number 10, my lord.
Vital witnesses of the prosecution, preferentially over all other witnesses. Least. Why she these we shall do it. Okay. Next. Yes.
The petitioner is in custody since 23/2024, madam.
23/3/2024.
Offense alleged to have been committed by the petitioner under section 294 and 304 of IPC.
Yes.
This is the second journey of the petitioner to this honorable court for bail, my lord. Earlier, your lordship was pleased to dispose of the
Call for CD. Call for CD. Let us. Call for CD.
My lord, with a liberty to renew the prayer after examination of material witnesses. In the meantime, material witnesses including the informant and eyewitnesses have already been examined. my lord.
Where
I have already served a copy of that.
where is that? You have not filed.
E-filing for the.
Okay, it's not, it hasn't
Yes,
come.
my lord, I have also certified copy, my lord. Your lordship can see.
Yes. However, liberty is granted to the petitioner to renew his bail plea after the material witnesses.
My lord, the petitioner is only 21-year-old man.
No, what have they say? Have you gone through this?
No. Let me supply.
It is not even
No,
there.
already supplied, my lord. Already supplied. Already supplied.
He say no, what can it?
ମାନେ ଏଥିରେ କିଛି ନାହିଁ ମାନେ ସେ ସମସ୍ତେ ଗୋଟେ ଭୋଜି ବାହାଘର ଭୋଜି ବଡ ବାପା ବଡ ବାପା ସେମାନେ ବାହାଘରରେ ସମସ୍ତେ ମାଂସଟା କଟା ହଉଥିବ ସମସ୍ତେ ମଦ ବି ପିଇଥିଲେ ଗରମ ପାଣିରେ ପଡିଗଲା ସସ୍ତା ହେଇଗଲି
You are putting it in the that is the
ସାନ ଭାଇର ପୁଅ ଆଉ ସମସ୍ତେ ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ ଉପସ୍ଥିତ ଅଛନ୍ତି।
What do you want to show from this? All of them have supported the case. All of them have supported the prosecution case.
Yes, ସମସ୍ତେ can receive cross examination. At the time of occurrence,
Which
informant man, informant.
PW?
One minor.
Yes.
I cannot take it. At the time of occurrence, I was sleeping.
Where are you reading?
I am not saying when the accused pushed my husband into the boiled water, kept in the kitchen. So what's can see?
Sir, can you please read the complete sentence? You can't read somewhere one line and say that.
Sorry, man. Sorry.
Either you read full or you don't read, or tell me the paragraph, I'll read.
I am completely illiterate. I don't know how to read and write. Odia, I cannot say who scribed the affair lodged by me at a Bodel police station. The contents of the affair were not read over and explained to me. I lost the affair after 10 days of death of my husband. After completion of his ceremony.
I have not seen the case. Yes, next. He was sleeping in the house. Next, which place? PW2.
Next, my lord. PW 3, my lord. I know the informant Semoti Kota as well as the accused Bolavanta Kota, who is standing inside the dock. I know the deceased Varun Kota, who is the husband of Semoti Kota. The occurrence took place 80 months back in the house of Hon'Ble Kota of my house during night hour at about 12 midnight. Preparation of a feast for the marriage of the son of Hon'Ble Kota was going on. I was engaged for cutting of meat. The deceased Varun Kota is the elder father of the accused Bolavanta Kota. The deceased Varun Kota and accused Bolavanta Kota made argument each other. They also pushed and pulled each other. The deceased Varun Kota fell into a big tub having boiled water. Manish Kota, myself and the accused rescued the deceased from the tub. Then Varun Kota was taken to Senapati Hospital and thereafter to a hospital at Raipur for his treatment. He died there in the hospital at Raipur after 7 to 8 days of the occurrence.
All of them have said that you have pushed. You have pushed. You are drunk and you have pushed. All of them have said.
My lord, I invite my.
Okay, you supply the copy and immediately after the case.
My lord.
Immediately after vacation. Yes. Next. Supply the copy. All of them have said that you have pushed.
21 years old minor.
That's right. You have completely drunk in the family. I mean, even the family feast you went and drank. You pushed your uncle in the boiled water. All of them have said, and none of them has spared you. Everybody has, in one voice, they have said. In cross-examination, they are little shaky, but the fact remains that they supported the prosecution. Wait, after vacation, I'll grant bail. Wait till. You are in custody since 23/3/2024. Okay. January. Okay. Yes. January. Second week January.
First week.
Second week. Yes.
My petitioner filing for modification of.
He should feel the. See, he should feel the pinch of it. He will get the bail. That's not an issue. Issue is see the character of this man. After that, after doing it, and in the village also he is going after drink and he started shouting. He has no regret also. Yes.
My lord, petitioner prays for modification of the order dated 9/9/2009, my lord.
53? Yes.
Petitioner prays for modification of order dated 9/9/2009.
9/9.
At page 11 of the IA, my lord. The condition number 1 is 10 lakh to be deposited. I pray for modification. Since 2009, my lord, I am facing the trial with that amount I require.
Where is that order, sir?
Order is page 11, my lord.
11 of who?
Of the IA, the present IA, my lord.
Why?
Starts at 9, the relevant is 11.
9/9/2009 order.
Yes.
10 lakhs.
So I pray that to be reduced, my lord. Since 2009, I had deposited and facing the trial. But since my pensionary benefits have been held out, I am unable to meet.
You already deposited. You want to refund it?
Yes, ma'am.
You have already deposited.
Yes, ma'am.
Yes. It's lying in. What is happening in the trial?
Trial not yet commenced, ma'am.
Yes, what is it?
So do not have that. It's a disposed of case. Neither the IA has been served upon him also.
I had solved that, my lord, the vigilance, last time my lords were.
It's a vigilance case. Vigilance matter.
Vigilance I had already solved, my lord.
What is that? All them.
Mr. Das, Sangram Das.
I just pass over there. Yes. 54.
54 modification of order, my lord. Modification of order, my lord.
Yes, Mr. Das. In item 53, just see what had happened is in 9/9/2009, he was enlarged on bail. And the condition was to deposit 10 lakh rupees. He has deposited 10 lakh rupees. And from 2009, the trial is still going on. Today, what he says is at least release that money because I am not getting pension.
It was the last occasion.
That's what he says.
May pray, my lord, sir, after lunch, the 5 minutes is there.
Yes. Okay, I'll pass. Yes.
May I discuss with him,
Yes.
sir?
Just discuss.
It was the last occasion it was there.
Yes. Yes. Yes, 54, what happened?
Only pass it over.
Pass over. Yes, 54.
Modification of order, my lord. There is a wrongly typed Belgium matter is not Belgium matter, my lord. Only unbeatable issue against the present petitioners, my lord.
Which order is to be modified?
It's 27/11/24.
What?
Page number 8, my lord.
Which part? Part
3.
Para 3. Petitioner was on bail. He was not on bail.
Non-bail. Prayer, my lord, the 307 case, my lord, NBW issue against the petitioners. And only
the application for the reasons stated in the application, the same is allowed. The order dated 27/11/2024 stands modified to the extent that the petitioner in para 3, petitioner was on bail. He was not on bail. He was absconding. Therefore, on the request of IO, NBW has been issued against him by the order dated 14/5/2024. By which court? 14/5.
Brahmandir, Ramanala, Brahmandir. My prayer is my lord. Only prayer, my lord. Same day dispose of both courts, my lord.
No,
Both courts.
that is not the
Only
scope
prayer,
of,
my lord. 307 only same day dispose of both courts below, my lord.
That can't be. Yes.
Only, my lord. Only.
That can't be because you have to file some other petition, not this. Under a modification, the guise of modification, you can't ask for these guys.
Inadvertently.
No, modifications are only correction. Small corrections I can do. In the modification petition, you are asking a substantive.
Permitted to file a fresh petition only.
You may file that. Yes. 55.
Petition of order dated 20/11/2024, my lord.
Yes.
In paragraph 2, 3, and 4, it has been typed as SDGM, but it should be SDM Bhanjanagar.
SDM court.
SDM.
For the reason stated in the application, the same is allowed. Next.
56 obliged.
Before my lord, withdraw and permitted to file fresh petition and dispense the
Which
certificate.
one? 56? Already council for petitioner seeks to.
Court permitted to withdraw, file a better petition.
There is a, you have pointed out some mistake, typographical mistake, whatever. I have to correct it. What permission? I am allowing your IA. If I don't allow, then I can understand. I allow here. You have pointed out some mistake has gone on record. I have to correct it. I correct it.
07 case, so.
Then you move some other application.
Yes, yes.
You move that. Yes.
And
56.
56, my lord. I have filed this IA for extension of surrender time.
Why?
Petitioners are daily laborers, could not surrender in time manner. 2 weeks time may be allowed to surrender.
Last time.
Yes, ma'am.
Surrender. Extension. PDC 2024 order. Extend till 31st December.
My lord, direction be given to the trial court to accept the late payment of a fine of 1,000 rupees.
Yes.
The
payment of 1,000. Yes.
57, my lord, I only pray for extension of date of surrender and the warrant. It's a Belgium matter.
Yes.
But I have
21/11/2024 order itla extension. December 31st December.
January. छुट्टी रही होची मझे
10th January कर दो till 10th January. ठीक है.
गोटे जिंस I want something before lordship, which my client is facing a problem before the trial court. Perhaps this is my first submission before a lordship. No other advocate may not be object to this application. There is absolutely no wrong so far your lordship's order is concerned. And I cannot draft that this is this way should not be passed or that way.
What do you want?
It's a Belgium matter. I tried my level best to convince the trial court that it's a Belgium matter. Court has already set aside the kept in abeyance the NBW, and I have directed me to deposit the amount of 1,000. I have deposited, and still your lordship is not convincing. And your lordship is in the court is not directing me to grant you bail or to direct you continue on previous bail. I will take you custody. You go and
you are on bail. Already you are on bail.
Then this is the problem I am facing, my lord. That is why I have filed this extension of time. Session Judge Malkanagiri.
I'll just put it.
Yes.
This is see, if you are on bail, that is the whole idea. You are on bail, you didn't.
This is the right order. It has been considered in a proper perspective. And it is understood in a other way.
It's very specifically written that the petitioner was admitted to bail on
exactly.
And because of his absence, I'm cancelling.
Very clear. Yeah, order a kitchen ticket code.
And these people read between line. I don't know.
I fail to understand. I try my level best to convince.
I'll
yes,
whatever.
It's all
10. These are the things, you know, in the administrative side one has to take care of. Nothing can be done.
58, my lord, modification of order dated 21/11/2024. My lord, in para 5, it has been wrongly written as 6/3/2019. It should be 12/9/2024. I have a corrected copy, my lord.
Para 5, yeah? Instead of 6/3, it should be
9.
That should be 24. I hit. 12/9/2024 ହବ 6/3/2019 ଟା।
ଆପଣ ଲେଖିଥିବେ କୋଉଠି ସେଇଥିପାଇଁ
No, no, my lord. Nowhere I have written, my lord. That is the problem.
ଅମିତ ନା ଅମିତ ଆଜି କେତେଟା ମୋଡିଫିକେସନ ଅଛି? 8ଟା 8ଟା ଜାଗାରେ ଦେଖ କିଏ କରୁଛି ଏମିତି ନା କି ସବୁ ଚେକ୍ କରିବ 8ଟା କିଏ କେତେ ମିଷ୍ଟେକ୍ କରୁଛି ଦେଖିବ।
Further print ମାନେ ଛୁଟିଟା ଅଛି।
ଏକ୍ସଟେନସନ ନା ଏକ୍ସଟେନସନ ଇନ୍ ଭିଉ ଅଫ ହଁ ଗୋଟେ ଥର ଗୋଟେ ପାଇଁ ଯାହା ହବ ତାପରେ ଇଏ କରିଦବ ଏକ୍ସଟେନସନ କରିଦବ। ୟେସ୍
Oblate.
59
May I please? Item 59 and 60, my lord. Both are Belgium matter, my lord. But in the order part, my lord, the NBW has been not been quashed, my lord.
What have you done?
And simply direction for move for
Usual order.
Execution of NBW state.
That is only state, my lord. Unless your lordship set aside the NBW, the learned court below shall not be released him.
What is this?
Only NBW has been stayed. Unless that has been quashed, my lord.
Or then comes Mr. Mishra and comes for the petitioner submits that although the execution of NBW issued by the court by order dated so has been stayed, still he is apprehending that the petitioner
Only stayed,
may be taken into custody unless the NBW is quashed. Therefore, he seeks modification. For the reasons stated in the application, the same is allowed. The NBW so and so is issued by so and so is quashed, subject to petitioner appearing before court on or before 10th of December. 10th of December. And paying the cost of rupees 5,000 as already directed. Both the cases are complete.
Item 60 also same, man.
60 or same, yes.
61.
61.
Very fair.
Adjourn, yes.
62.
62 kindly pass over, my lord.
No, pass over.
62, my lord. Let it come after vacation, my lord. What's the play, my lord?
After vacation.
My lord, with consent of both the parties, my purpose is to get the money. His purpose to get rid of criminal charge. My lord was granted 4 months.
Therefore, I know.
No, my lord. He's playing fraud with the court.
No, my lord.
If he genuine.
I'll not delve open anything. I'll just put it after vacation. Yes. I'll look into that. Otherwise, I'll dismiss it. Yes. 63. Huh? Huh?
This is a small matter, my lord. Yes, the small matter with my lord. Here, what has happened, my lord? I was the one of the director of the accused company. My case is they are compelling me to repel the company. I have resigned from the directorship since 2011 and 2013 in 2 companies. I may be prosecuted in individual capacity. That is, I am not telling you, my lord. They cannot compel me to, my lord, since I was not. I was the only founder director. They are compelling the order to say that you have to repent him.
Show me.
My lord, that order. That is why your lordship has scared the entire.
Yes, Mr. Naik, you are appearing.
Yes, your lordship. Lordship, this matter can be disposed of. Lordship,
yes.
The small issue here is that who will represent the company if in case the company is an accused? Your lordship may kindly come to 2 provisions only, 3052 and 3056.
Yes.
3052 says that when a corporation is the accused person, CRPC.
Yes.
Where a corporation is the accused person or one of the accused person in any inquiry or trial, it may appoint a representative for the purpose of the inquiry or trial, and such appointment need not be under the seal of the corporation. In this case, your lordship, the company had never asked any representative to represent in the trial court, and the remedy lies in point 6, your lordships, 3056. If a question arises whether any person appearing as the representative of corporation in any inquiry or trial is or not such representative, the question shall be determined by the court. Then the matter may be remanded back to the lower court. He will decide it, your lordships, who will represent
Your
the company.
lordship see the order. Thereafter, your lordship, this court has passed an order in a similar case, no, as your lordship has, he is read the. We read 305. Your lordship has read. Kindly come to the CRPC section 63.
Yes.
Service on summons on the corporate bodies and societies. How this service has to be made, madam?
Yes.
Service has to be made to the company. It is the duty of the company to select who to repent the company. You cannot issue a summon, repented that the summon is written that repented by Signaran Das. That cannot be there. Your lordship, I am reading of this service of summon on corporate bodies and society. Service of summons on the corporation may be affected by servicing on the secretary, local manager or other principal officer on the corporation by letter sent by the registered post addressing the chief officer of corporation in India, which is case in service shall be deemed to have been effected when the letter is arrived in the ordinary course of post matter. Now your lordship may come to page 43 of my matter brief. That order by which he has compelled me to repent the company.
I think it needs hearing. Right.
No, Lordship, it can be decided. Your Lordship, it can be decided.
Do the conflicting provisions are there. Yes, I'll decide it.
Your Lordship, only one small request. Your Lordship,
first week of January.
First year, second.
Your Lordship, one small request. Your Lordship,
Yes.
there is a stay of the proceedings. The stay should be only qua this company, Your Lordships, not other petitioners, Your Lordships.
Stay qua the petition.
Stay of the proceeding is there. It will not affect. It is the first week of reopening day, Your Lordship. I am
no, Your Lordship, pass this order. Your Lordship, I'm
getting with all.
No, he has a problem. 10th, he say 10th. I'll clarify that. Okay.
Madam.
Yes.
So far as the petitioner is concerned,
it's qua the petitioner. The stay operates qua the petitioner.
Yes. I have no issue.
Qua the company rather. Qua the company.
Yes. Judgments of free copy of the order may be provided.
The stay order passed by the interim order. Interim order passed on interim order needless to say the interim order shall continue to the date appearing, and it is made clear that the interim order is interim order for stay for the further proceeding in so and so case is for the accused company. For the
accused petitioner.
Yes.
It's a free copy of the order.
First week or second week,
Second week.
Yes, next.
I'm sorry, my lord, I am interrupting. Item 61.
61, he has a personal difficulty, so therefore he shorted time.
Can it be Monday?
Yes.
Because
Monday, 200 matters are there. If you want to come Monday, come. Nothing will happen.
Why I am saying,
whatever may be.
They have taken a decision to dismiss me from 23rd by the board. The present board is giving.
So what can I do? 200 matters. If you want, I can keep it.
May I pay my lord one thing? Only thing I may be protected up to one vacation.
Conviction can't stay. We can't be stayed like this.
No, he says
very
the vacation. Then after vacation, I didn't have any objection. Only because it was not stayed.
Cannot be stayed.
That's why I not decided to finally it will happen.
That is the reason. Yes, next. Yes.
Your Lordship, a free copy of the order may be provided.
Any date, man?
He will fix a date. I'll adjust and fix a date. Yes.
Let's say item 64.
Vacation. After vacation. Yes.
Interim is continued.
65.
My lord, here your lordship. If a lordship permits,
item 64.
Mr.
It's short and adjournment.
Item 64.
Opposing the
yes, my lord. Because on the last occasion,
Just a minute. Can it be 6th or 7th like this?
7th.
Mr. Party is desperate, my lord, this matter to be taken up.
7th.
Separate compulsion with you. And he aggressively pursued these matters, but he was with me in the advocacy office. Can it be 2 p.m.?
See, 2 p.m. has no sanctity, you know. 2 p.m. all these things happen.
3 p.m. or 3:30, any time, Lordship.
3:30.
Yes. Lordship may cite my example. Lordship may cite my example.
I want to that makes no sense.
I know the pressure of this court.
Makes no sense.
Tremendous.
Yes.
My lord. May I kindly submit? Item 64.
You are for opposite party.
Yes, brother. I am appearing for the opposite party victim. And since the date they have obtained the interim protection from this honorable court, they have not been appearing, they have been seeking adjournment, and today also they are seeking adjournment of this case. I humbly pray the interim protection must be set aside, my lord. It may be vacated.
Interim order was granted in 22.
But yes, my lord, it's a case of 22, my lord.
2020.
Yeah, they have been seeking repeated adjournments in this case.
That's the whole problem.
Yes, my lord.
The reason I don't give any.
Yes, my lord. Your lordship on the last occasion also.
This way or that way, finished up.
Your lordship on the last occasion only dictated that if they are seeking any more.
Interim order is there. You will not file requisites and send the juniors, get the adjournment. These are not the.
Yes, my lord. With great difficulty.
Last time also you had short time.
With great difficulty, I have mentioned for the victim, I have mentioned and I have got it listed, my lord, today.
See, you took stay order on 7/12/2022.
My lord.
Very next day, that is 1/11/2020, nobody appears. Nobody appears for the petitioner because the interim order is there, nobody appears.
My lord.
Thereafter also nobody appears. Then there is a request for adjournment. Now it is request for adjournment. There should be.
Humbly pray, let the interim order be vacated and let it be kept for final hearing. I am ready to conduct the case, my lord.
The coordinate bench has granted interim order. I can't vacate it. Like this. I can't vacate it. Whatever there is an interim order, I can't vacate it.
But they are taking undue advantage of that.
Can we heard on? Yes.
Can we heard? A short date may kindly be fixed.
It's made clear that no further adjournment shall be granted. If the petitioner seek adjournment at the next date of hearing, the interim order passed on
7/12/2022
shall be vacated. Yes.
Those may kindly fix a short date, my lord.
Yes, next.
Grateful.
Next.
Please, your lordship. My lord, here, your lordship. There is a plea of alibi there, and then the same day of occurrence, there is 2 cases was filed. After lapse of 2 months, there is 1/6 case was filed, wherein the cognizance was taken. My lord, they already appeared. Let the matter come after vacation for hearing, your lordship, for final hearing and disposal of the case.
Okay.
Interim order will continue.
On the request of Mr. Panda, release the matter on the second week of
interim order is there, your lord.
For interim order to continue.
Public.
66. Well, at 66, you may remember that the matter is related to the students whose then state has to clarify about the issue. This what's 161 statement says about against which students. I just now I am talking to this state councils. See that only 161 statement is there. No specific averment is there in this regard. I also examine the same. This court below, when acquitted a minor in this case, specifically noted that no case is evidence is made out against any of the accused. That's I have WhatsApp. I have that order.
Where is that?
That order I can
place it. Then place it. Place that order.
Just a minute, my lord. I am just placing.
Get that order and place it.
Yes. This order is with me, my lord. I am just placing.
But unless it is there on record, what can I do?
That order I will file this.
File it.
After lunch, can I?
After lunch.
It is fixed to 2 p.m. That's why
it has to be brought on record.
Yes.
It has to be brought on record. All these things you.
Memo I can file.
Yes.
Today itself.
File it.
It is 2 p.m. Let's make it 2 p.m.
2 p.m. I don't know whether I can.
Yes. Oh, then.
Yes.
Let
him file it. We'll see. Yeah? Okay.
Or if not 2 p.m., then Monday or Tuesday, according to the lordship's convenience.
24th. If it is
24th, yes.
24th, yes. 67.
67. That 24th is same 2 p.m. Yes.
Yes.
Passing of proceeding on the ground of
or even the
compromise.
Before lunch, yes.
Dispense with. What are the offences?
376 and POCSO, my lord. But the one
POCSO
statement does not reveal any offense.
The POCSO is there. Investigation is still going on.
Yes, ma'am.
Yes. Mr. Bishwal, what do you say?
164 statement, no offense.
If the 164 statement, no offense under POCSO is made out, then you file the charge sheet, at least I will quash it. Because after the POCSO, I can't quash.
No offense.
No offense is made out, then file the charge sheet. Because this is at the stage of, investigation. Mr. Bishwal,
I'll protect me till then, my lord. Since last 3 occasions I have mentioned.
See, I don't know, except FIR, you have not filed anything. Everything you are saying orally. You have knowledge that 164. Show me 164. How do you know then? At least show me. You file an FIR, you say that in a POXO case, you say that.
164 statement.
First of all, you are asking for a question. I am giving intervention to you.
Your lordship may
The problem, the big problem here is neither the pleading nor the documents, you file nothing. Just throw one paper or two paper and say that.
Since charge sheet has not been filed, I cannot file 164.
You please.
With learned state counsel.
But you have a knowledge, show me the 164 now. If you have rough copy.
I have obtained from London.
I can't help you.
May I read
this petition is so sketchy.
May I read this?
Nothing can be given in this petition. So sketchy. Nothing is written. Simply written. Yes.
And 164. May I read the 164 statement?
No. You place it on top. Yes.
69.
At least proper petition should be filed. That is also not filed. What to do?
They have appeared personally, my lord, and
I have recorded and dispensed also. That's the reason.
On 28/10, it was.
Mr. Vishwal seek an adjournment to obtain instruction regarding the status of the investigation, and let him do so positively by next date of hearing. Yes.
164 statement is with my learned state counsel, my dear lordship.
Next,
May I please?
Yes.
This is that case where, my lord, prosecution has been initiated under section 385, 387, 34 of the Indian Penal Code, my lord.
I'll hear it. Entry order to continue. Case of
entry order ଦେଇଥିଲେ ସେ surrender करला. Surrender करला, bail move कला, bail ଦଉନାହାନ୍ତି. Problem is that your lordship had said that parity will be maintained, my lord, but the court below is not granting bail, my lord. That is the whole difficulty. That is why, my lord.
Including the parity. You challenge that order at least.
Ne ଦଉନାହାନ୍ତି, reject କରୁନାହାନ୍ତି କି allow କରୁନାହାନ୍ତି. Problem ହଉଛି ସେଟା.
Then what can I do? I have to examine this. We'll see.
No, that has to be examined, my lord. Here, there is nothing, my lord.
But in these kind of cases, bail should be granted. I don't know.
Yes, my lord. But he is not granting. The difficulty is that, my lord. That is why I am saying, my lord.
That's the whole difficulty is because of the reluctance of the lower court.
Lower court,
bail,
parties are coming here.
Plugged with all the matters.
That is the whole difficulty. They are not understanding what is the parity. They are saying
now
what is
I stayed the execution of NBW. They said no, you are. I'll take into custody.
Yes, that is the whole difficulty. एथिरे से कहउचंदी जेतु हाई कोर्ट दैचंदी सेटा पैरिटी हाई कोर्ट मेंटेन करबे ना आमे केमति करबे. This is their observation.
We'll see after vacation.
Let there be stay of further proceeding.
Move application.
No, I have filed the application that is pending. That is
application for adjournment, and if such application is moved, same shall be considered. We will decide that matter is submitted before this court.
Yes. I'll file a separate application.
My matter item 68 has been left.
Yes,
my item 68 has been left up. 68, my lord. I am in 68, my lord. I am for the petitioner. Well, how can it be urgent, my lord? I take notice by special messenger by lordship.
There is no point asking me. You ask your brother who has mentioned it.
No, my lord. I have not been informed. How can my matter has been urgent?
What can I do? Can I adjudicate on this issue?
My lord, that
if your brother in the bar does that, then you have to have a grievance against him. Tell him.
My lord, if they take time, my lord,
I think you might have done the same thing with him in some other matter. He has taken revenge. Reciprocated.
But matrimonial dispute, my lord, judgment has been passed because of this.
Okay, I'll give a short date. Wait, I'll give a short date. Yes.
Nothing remains, my lord, because final report has been submitted, a complaint case, judgment pronounced. I am old age at 75. I'm a pro.
But in his absence, what can I do? You just.
My lord, how she has taken time.
How do I know? How do I know this has been doing? You people are doing like this. Then what I'll do is I'll not adjourn the matter. In the morning, mentioning, see, you should have deputed someone if you know your opponent is
Because, my lord, by registered post notice.
Let us not waste further time.
Long absence.
May I please, your lordship?
17,
Yes. May I please, your lordship? See, a case of quashing of criminal proceeding, my lord. Already your lordship had this matter, my lord. This is a small matter, my lord. Maximum punishment is 6 months, and petitioner,
interim order is there.
petitioner is a student, my lord, and that
Interim
matter-
order is there.
No, my lord. Yeah, the difficulties is that, my lord, on January 2nd week, he is going to appear the exam. Petitioner is a student, my lord. At the time of occurrence, he was juvenile, my
Who
lord.
prevented you from appearing?
No, my lord. Yeah, that is not.
I have
whole
stayed
thing.
the proceeding.
Already stayed, my lord.
Then
They
you appear. Who stops you?
small offense was, sir, my
Oh,
lord.
that's
6
right.
months.
But okay, I have stayed it.
Maximum
Let's
punishment is
continue,
6
because
months. Already
see the timing. Yes.
twice they have taken time, my lord. On last occasion, your lordship was intention to
Interim order
pass the
continue.
proceeding.
Interim order to continue and give a short date. Huh? Yes.
71.
I am appearing on behalf of Mr. P.K. Samutraya. I am for the petitioner that the joint compromise affidavit has already been filed. Lordship, due to the health problem of the petitioner, he could not come to this court. Let it kindly taken up on Monday. Lordship, Monday. Yes. Yes. Interim order continue. Lordship, interim order.